Good afternoon. Good afternoon, Your Lordships. This is Council number 1, representing the petitioners in the case of Walter White versus Republic of Indiana. The Council seeks permission to collectively address the bench as Your Lordship. Much obliged. Before the Council starts her submissions, the Council would like to submit the compilation of the compendium if that is permitted. Much obliged, Your Lordship. If Your Lordship is well versed with the facts of the case, the Council would like to proceed with the points of contention. Or should I brief the facts of the case? Much obliged, Your Lordship. Presently, we are situated in the country of Indiana. Here, 60% of Indiana's population, Your Lordship, is below the age of 35. And the NDPS Acts and narcotics and psychotropic substances related provisions are very strict in this country. After certain raids that were conducted in March 2023, an alleged drug kingpin known as Walter White was arrested and taken into custody. Now he was put in the prison of the Trihar jail that is in the capital city of Delhi in Indiana. It is most important to note that this Walter White is not a citizen of Indiana. He is a citizen of India. And we are in Indiana. So he is a foreign national to this country. Additionally, Your Lordship, once he has been placed in the prison, it has been noticed that he was continuously monitored by CCTV and AI CCTV cameras that were not just in the kitchens, barracks, etc., but also in the cells of the prison. Here, he was lodged in a maximum security prison, which is already given with lot of restrictions. Upon this, there were CCTV cameras that were placed. So he wrote a letter to the Chief Justice of the country, and the Chief Justice of the country, with their permission, turned it into a PIL, which came up for hearing before this Honorable Court. Additionally, at the same time, the accused filed for a bail in the Delhi High Court, which was but the bail was granted. However, the condition given on the bail was very extreme. It stated that Walter White will 24/7 provide his live location to the station head officer. Now, this condition of bail has been challenged in the Honorable Supreme Court of the country via a special leave petition. Now, these two cases are before the Honorable Supreme Court to decide on the right to privacy of it being infringed or not. If there is no further grievance with regards to the facts of the case, the Council would like to proceed with the points of contention, Your Lordship. Much obliged, Your Lordship. So, this is Council 1, and I will be dealing with issue number 1, that is with regards to CCTV cameras, AI-powered CCTV cameras, and their infringement of right to privacy. My co-counsel will deal with issue number 2.
Before that, why should this court should give jurisdiction to this case, especially petition? That's what you did, right? Have you availed any alternative remedy before approaching this court?
Much obliged, Your Lordship. So, in the present case, after noticing that there were several CCTV cameras, even in the cells of the prison, firstly, my client, Walter White, he has written a letter to the Chief Justice of the Supreme Court. The Chief Justice of the Supreme Court, at their behest, converted this into a PIL. Secondly, once the order of the High Court has been given imposing the bail condition, that has been applied by Walter White as a special leave petition. Now, that is under Article 32 and Article 136 of the Constitution. The Supreme Court has clubbed this matter under Article 139A, giving the jurisdiction to this court to hear this current matter.
What is the actual name of this when person writes a letter to the judge of the Supreme Court and they entertain the matter as a PIL? What is the jurisdiction named as?
I understood the question. The Council will shortly get back on it. I'm currently not able to recall the name. Yes, it is the 6th. I will get back on it. Much obliged, Your Lordship. Thank you. So the Council will deal with the first issue and will directly hit the bullseye as to how it is violative of right to privacy. All of us in this courtroom are clearly aware as to right to privacy, even though it is of utmost importance, it can be violated in certain circumstances and it can be diminished. Especially for prisoners, it is already diminished. The petitioners are also very well aware of it. However, there are certain guidelines to be followed when you are violating that fundamental right of the prisoner. These guidelines are given by the Honorable Supreme Court in the case of Justice K.S. Puttaswamy versus Union of India. Now the council will just clearly state what are the guidelines or what is the four-pronged test that is laid by the Supreme Court and how it is not satisfied by the state. Once that is clear, it is a clear violation of right to privacy. If the council may please proceed with the four-pronged test. Your Lordship, here, I kindly request the bench to please peruse through page number 60 and 63 of the compendium that is duly submitted. Apologies, because there's only one compendium that is available. So, Your Lord,
Page number?
60 and 63 of the compendium, Your Lordship. That is an exact replica of the guidelines that is given by the Supreme Court in this case. Just, I will read it verbatim for your. Is there any clarification that I have to? Yes, Your Lordship. Justice K.S. Puttaswamy versus Union of India, AIR 2018. Yes, Your Lordship.
So, Counsel, I have a question.
Yes, Your Lordship.
Is there a reasonable expectation of privacy inside a prison?
Understood, Your Lordship. Here, once all of us are very well aware that inside a prison, already there are diminished rights of the person. However, in the case of Neelabati versus state, in state of Orissa, the court clearly ruled, if I may please verbatim read that, there is a great responsibility on the police or prison authorities to ensure that the citizen in its custody is not deprived of his right to life. His liberty is in the very nature of things circumscribed by the very fact that of his confinement. Therefore, his interest in the limited liberty left to him is rather precious. So, he is already in a high security prison, my client. And that interest, little amount of privacy that he has is also being curtailed. And the council will try to prove on how all the four prongs of the test is not satisfied, Your Lordship. If there is no further grievance, can the council please proceed to prove as to how the four tests are not satisfied? Much obliged, Your Lordship. The first test, I will verbatim read from the judgment to ensure the sake of brevity and clarity. The first test is that the action must be sanctioned by law. This test is partly fulfilled by the state, Your Lordship. Action must be fulfilled by law. That is, CCTV cameras must have a backing of law. Here, there are several prison rules, Delhi prison rules, model prison manual, etc., which provide for CCTV surveillance. This part of the action is sanctioned by law and the petitioners completely agree with it. However, Your Lordship, the petitioners are stating that there is no sanction of law for AI-powered CCTV cameras, Your Lordship. There is nothing, no rule, law, bylaw, regulation, guideline by Supreme Court, etc. There is nothing. And when such a big change is being brought by the state into the prisons, there was not even a mere notification that was released by them.
Counsel, isn't that all outcome-based? The outcome of the rules is to have security, maintain, surveillance inside the prison. How I achieve the objective is not something we can fetter the hands of the executive. They may use drones, they may use cameras, they may use AI-powered cameras. Do the rules stop that?
Much obliged, Your Lordship. However, if I may just rephrase what you said, here we seem that the end is very important. However, in the present case, when prisoners themselves have a very diminished right of privacy, the means that you're using to achieve the end is also very important, Your Lordship. This means that is being used is not proportionate. That is the third test that the council will try to satisfy in the third prong of the argument. So firstly, the first test of law is not satisfied, that it is not sanctioned by law. Mere CCTV cameras are sanctioned. What the council is stating is the state also has the right and duty to implement AI CCTV cameras. However, none of the country was not given any notification with regards to it. No guideline, rule, bylaw, not even a notification in the official gazette, Your Lordship. This much step of this big nature has not been notified to anyone. So this one is not satisfied is what the council trying to state.
See, AI-powered CC camera footages are allowed.
Yes, Your Lordship.
But what shall be the nature of CC camera, whether that need to be specified each and every time, whether the code have that, or is there any guidelines needed to specify the nature of CC camera, whether it can be AI powered, or whether it should be audio with audio, or whether it should be speaker, whether it need to be specified?
Much obliged, Your Lordship. So, if I may draw an analogy to answer this question, this is a step that is a very drastic step. For example, whenever any amendment or a change or a new thing that is being introduced by the state, it is always notified in the official gazette. For example, there are several amendments made to the IT Act or several rules that come by virtue of the IT Act. Now, it is always notified, so the persons are informed of it. For example, the intermediary guidelines. So the intermediaries were made aware. The intermediaries were made aware as to what sections or what rules will they be liable under for what certain acts. Here, that was not done in the
To
present
what
case.
extent prisoners can avail these rights?
Yes, Your Lordship. That exactly is proven in the third point of proportionality. The council is just getting there. For the sake of brevity, it's just that the proportionality is not achieved because the means that they are using is not satisfying the end. Coming to the second test, Your Lordship, with all of your permission, there must be a legitimate aim. However, the petitioners do understand that there is a lot of violence or mishaps that happen in prisons for which the state is, yes, Your Lordship, for which the state is introducing such measures. There is no legitimate aim that is completely established, Your Lordship, because what is that that can be achieved only by AI-powered CCTV cameras and not normal CCTV cameras, that too inside the cell of the prisoner. Because this is utter violation of right to privacy.
Can you give a difference between normal CCTV cameras and AI-powered CC cameras?
Much obliged, Your Lordship, yes. So the primary difference is AI-powered CCTV cameras, along with capturing real-time data, they also recognize a lot of biometrics. That is your fingerprints, your iris scans, voice modulation, etc. So privacy as given in Puttaswamy judgment, that is in page number 62 of the compendium, has three aspects. Personal privacy, informational privacy, and privacy of choice, Your Lordship. Here, the personal and informational privacy both are breached when an AI-powered CCTV camera is implemented or established in a prison complex, that too in a high-security prison complex, within the cell of the inmate, Your Lordship.
Counsel, have you taken a plea of violation of Article 14 in your submissions?
No, Your Lordship. The MOOT proposition restricts
So why we feel that is important is that all prisoners are not alike, correct? All prisoners
Yes.
are not alike.
Yes.
So this is a maximum security prison complex.
Yes,
In
yes.
the maximum security prison complex, this is what is happening. That does
Yes.
not mean all prisons have AI powered or even CCTV cameras inside the rooms or and so on and so forth. So as a differential base, on a differential basis, why can't the executive be given the power to create a maximum security prison complex where alone they are authorized to do so?
Understood, Your Lordship. I was actually coming to that point itself. In paragraph 7 of the MOOT proposition also, it has been clearly stated that these AI-powered CCTV cameras and CCTV cameras inside cells are established only in maximum security prison complex. And even the respondents in their written submission of the memorial, in paragraphs 35 and 36 of their submissions, clearly stated, if I may please verbatim read, that the petition...
You refer the page number.
Page number 25, Your Lordship, of the respondent's memorial. They have written that the petitioners may continue drug traffic. Apologies, Your Lordship. Should I give another copy?
Which paragraph number, ma?
Paragraph 35 and paragraph 36 of page number 25, Your Lordship. The council seeks permission to proceed. Much obliged, Your Lordship. To answer Your Lordship's question, it is in this only. They stated that the petitioners can continue to do drug trafficking even in the prison. And additionally, this AI-powered CCTV cameras are established to ensure that he is not coordinating with external parties to fund terrorist operations. Your Lordship, the problem lies here itself. It is a maximum security prison. is the state doubting its capabilities? Because how will an external source enter a maximum security prison? Or what type of contraband is the...
Are you aware of the ground reality that is prevailing in the prisons?
Understood, Your Lordship. Again, coming to that point.
No, no.
Yes.
What is that?
There are a lot of contraband that is retrieved even from the maximum security prisons.
So there are mobile phones retrieved from the prisoners.
Yes, Your Lordship, yes. But
So under such circumstances, something needs to be done to address those issues.
yes, Your Lordship.
Right?
Then, yes.
So what they say is correct then.
No, Your Lordship. If the council may please proceed to answer that point, something has to be done
Council, I
to...
want one question.
Yes, Your Lordship.
You said the CCTV, due to the CCTV, his fingerprints are taken and eyes are screened. When a person is arrested, immediately the government, the police officials will take the fingerprints. So nothing is been violated in this. So every prisoner will be screened before put him in the cell. They will be screened. They will take the fingerprints. Everything will be done.
Much obliged, Your Lordship. If I may please answer His Lordship's question first and then I will proceed. Much obliged. So, Your Lordship, something has to be done about the contraband that is being within the maximum security prison cell. But what has to be done should be done stepwise and less intrusive means should be taken first. If we see, Your Lordship, the maximum limit or the prescribed limit for...
Is there anything in your proposition to show that there were guidelines issued by the government insofar as the installation of AI-powered CCTV, or for that matter CCTV inside the prisons?
No, Your
Is
Lordship.
part of the proposition? Is there any guidelines that have been given?
No, Your Lordship, nothing. Nothing as such.
It is an arbitrary act by the part of
Yes,
the
Your
government.
Lordship.
Is that your plea?
Yes, Your Lordship. It is completely violating right to privacy. The council actually wanted to invoke Article 14 because of arbitrariness that is involved. However, due to MOOT propositions guidelines, we are sticking with 21 itself. So, Your Lordship, just to answer that question, the prescribed limit in Tihar jail is 5,200 prisoners, Your Lordship. But how many are there? It is fourfold, Your Lordship. No. Extremely sorry. That was a figure of speech. I humbly apologize. It was... Yes. But right now, there are 19,500 prisoners as we talk today, Your Lordship. So firstly, there is a lot of overcrowding. We are not no one to direct the state, but it is a mere suggestion that first, this thing that is there must be taken care of instead of directly violating the rights of someone who is already in maximum security prison cell. And to answer Your Lordship's question that already fingerprints and everything is scanned. However, Your Lordship, in AI-powered CCTV cameras, he is being under vigil and surveillance 24/7. His voice is also being recorded and every movement is being recorded. If the council may kindly state...
Except the washroom. That you are not mentioning. Except the washroom.
Yes, Your Lordship, yes. If that is there, then this case would be something else. But yes, Your Lordship, privacy is completely required in the washroom and the convenience room where it is barred. However, it is also required in cells. If the court, if the council can draw an analogy, Your Lordship, in Kharak Singh case, the Honorable Supreme Court clearly ruled against the domiciliary visits. Now there, domiciliary visits happen once in a while, once in a fortnight or very rarely. Now the court itself ruled that in such circumstances... Yes, Your Lordship.
Have you ever come across how does a cell, high security prison look like?
Yes, Your Lordship.
From where do you get it?
There is one in the Bangalore Central Jail. So I have visited one.
So the high security cells, do they have a separate common restroom, toilet and bathroom, or is it well within the...
It is within, Your Lordship, because within the cell, because it is one entire complex that is given to the high security prisoners.
Within the cell, installing a CCTV camera inside the cell, won't it affect his privacy to that extent that, you know, he cannot even attend nature's call without being monitored by the CCTV?
Understood, Your Lordship. The same...
Have you taken that as a plea?
No, Your Lordship, because the same has been dealt with in an international case of Scarmento, which is given in page number 93 of the compendium, where it was clearly held that those areas are anyway restricted from the vigilance of the CCTV camera due to its positioning. So we are not completely questioning the entire authority of the state.
The question must go to the respondent. installing the camera in a proper way. So somebody goes into an hiding or not in the line of sight of the camera, then they can.
It is only restricted to washrooms and convenience room.
No, I'm talking about a high security prison and a cell which has a drug lord in.
Alleged, Your Lordship.
So in that case, so would he be allowed to walk free within the corridors of the prison?
No, Your Lordship. Anyway, he's already screened completely 24 bars.
I don't know whether you've taken the plea or not.
Much obliged, Your Lordship. If I may just conclude with that Kharak Singh case that the council was citing. Domiciliary visits once in a fortnight only, the court ruled in page number 44 of the compendium, para 33 of the judgment, which is highlighted for your reference. That is only unconstitutional and that is only violating right to privacy.
Because that was depriving his right to sleep. Mostly they were knocking
Yes,
at the,
yes.
at odd times. Here, see, there's a camera, but otherwise he can carry
Yes.
on with his life.
But Your Lordship, another alternative the court many times produced or suggested was that visit at a different point of the day. But here, he is under vigilance the 24 hours. So there is one mentality that is fixed inside the person's mind. And yes, Your Lordship, the council seeks 1 minute to kindly sum up. Much obliged, Your Lordship. Here, lastly, there are less intrusive means also available, which include periodical check-ins, etc. Even the D.K. Basu judgment that is given by the Honorable Court states the same. There is, in paragraph number 26 and 29 of the judgment, Your Lordship. Yes, Your Lordship. Where CCTV guidelines were given, but the court also subconsciously gave a safeguard stating that non-official visitors will do random or surprise checks. Now, there are so many other less intrusive means to check what the accused is doing. He has been arrested in March 2023 and he has been recently let out on bail, Your Lordship. For 2 years, he was in the cell for 24/7 under vigilance, Your Lordship. The council would like to state 2 last points and conclude. The 4th test of the K.S. Puttaswamy states that there must be sufficient safeguards against the abuse of such power. Here, no safeguards are given, Your Lordship, because once it is AI-powered CCTV camera, there is no safeguard. Neither the IT Act talks about it, nor the SPDI rules. So what happens if there is an abuse of this power that is given? Because AI, to operate an AI-powered CCTV...
You're pleading that you're prejudiced by the mere installation of an AI-powered CCTV. So what are the prejudices? I mean, how are you prejudiced first?
Why?
How are you prejudiced?
Yes, Your Lordship, because it is violating right to privacy.
How?
That is what, Your Lordship. He is monitored 24/7. Your Lordship, that is
He's a prisoner.
Yes, yes.
He's a prisoner.
Yes.
He's got rights. Of course, we're not saying that he doesn't have rights. He's got every other right except while he's not under incarceration. So under such circumstances, what is the prejudice? He's been monitored. His movements are monitored. You know, he's calling himself a drug lord. Even his life and his
He doesn't call himself, Your Lordship. Okay.
No, that is what the government says, that he is the kingpin.
Understood, Your Lordship. It's alleged and it's just an accusation. It is not proven yet, but
The
understood.
presumption is on you, under the NDPS.
Yes, Your Lordship.
Yes.
The case has not
First
come
and
to...
foremost, I am a own doubt. How was he let out on bail?
Yes, Your Lordship. Right now, he is on bail. Once
How was
the...
he let out on bail? They have to answer. Yeah, anyway.
Yes, yes. He was let out on bail because reasonable conditions were satisfied, which is required, which my co-counsel will anyway prove. But there were reasonable conditions that were satisfied. That is why he was let out on bail. If the court presumes that he is a threat to the society or of much harm, then bail only would not have been given in the first place, Your Lordship. So, Your Lordship, just to conclude, even in the case of Russia, Gorlov versus Russia, same thing happened, Your Lordship. AI-powered CCTV cameras were there. 2 men were continuously monitored. However, there was a female who was monitoring them. Even in India's Baikula prison in Mumbai, the same thing happened and women went on strike because they were completely and constantly criticized for the way they were dressed because on what was observed by the male guards. And for the Russia case also...
Can that be an apt correlation to the case in hand? Because a male officer monitoring a woman prisoner is something different from an AI monitoring an inmate of a prison.
Yes, Your Lordship, but AI is not a... There is a small correlation, Your Lordship. The answer to that is AI is never a replacement of human. Even though AI does its work alone, there is a human surveillance or supervision that is required to it. So all the data that is collected by AI is stored and transmitted, and it can be viewed again later. That if that grievance resolves.
Counsel, how will you substantiate that it is against legitimate state interest?
It is against.
Against legitimate state interest.
The council is proving that only. It is not against legitimate state interest, Your Lordship, because the respondents might state that it is against legitimate state interest, but there is no against legitimate state interest. He's already in a high security prison. What else can he do, Your Lordship? He's confined. All bodily checks have been done. All the fingerprints and all the measure, everything has been taken. So there's nothing else he can do. And like said in the Honorable Supreme Court rightly ruled in the Neelabati case, the very limited right to privacy that is accessible to the prisoner, at least that should be protected, and that is rather precious to him.
What is the limit of the rights of the prisoners?
Right.
Where we will balance the rights of the prisoners. They cannot be equated along with the ordinary citizens, right?
Yes, Your Lordship.
Where is the limit?
Yes, Your Lordship. Now here
Where
there
can
is...
we, keep a borderline between the rights of the prisoners and the rights of the citizens, and how far these rights can be entertained by a prisoner?
Much obliged, Your Lordship.
Which case law deals with this, and what is the dictum?
Much obliged, Your Lordship. If I may just answer first. So, firstly, once a prisoner enters the prison, his rights are already curtailed. Freedom of movement, etc. are already curtailed, which is different from a normal prisoner. Now, his right to privacy will be completely curtailed if he is under surveillance 24/7 within his cell. What the counsels for the petitioners are arguing is there can be CCTV cameras throughout the prison complex, but barring the cells, Your Lordship. Because washroom and convenience room requires utmost privacy. However, within the cell also, because it is the number of years they spend on the cell, into 2 will be the mental agony that will be caused to that person, Your Lordship. If that may satisfy. The council would like to just say 2 more points before I leave.
No.
Apologies, Your Lordship. Apologies, Your Lordship. This seems a little important, that is why. Yes, Your Lordship. So the council...
Before that, I have a question. Whether he is a national or a foreigner?
He is a foreigner, Your Lordship.
Foreigner. So you have gone through the Foreigners Act. You have gone through the Foreigners Act. What it says?
Yes, much obliged, Your Lordship.
Section 3, what it says?
The council is not very well aware, but much obliged, Your Lordship. The council will clarify as to why this is applicable to him. Article 21 is what we are claiming for, and Article 21 starts with no person shall be deprived of his right to life and personal liberty. And the Supreme Court in various cases ruled that no person will include foreigners, and also even R.C. Cooper case they also said even company will come under this ambit. So even though he's a foreigner, he is residing in India and he's a prisoner in Indiana right now. Thus, he has the right to be protected under Article 21 of the Constitution.
To what extent a prisoner's right to privacy can be entertained?
Your Lordship, that's what, there is a superficial line and that should not be crossed. There is not...
Case law.
The council is not exactly able to remember, but...
When you talk about privacy, intrusion of privacy, the first and foremost thing that you have looked into is what are the guidelines that are laid down by the Supreme Court to bestow certain rights on an inmate of a prison. So an under trial prisoner, a convict, now whatever the proposition says, he's an under trial prisoner. So what are the rights? Does he have rights first and foremost? Which judgment gives him the rights under the Constitution? Though being a foreigner, now
Yes.
he is here.
Yes, yes.
So there are certain things we should avoid. You can always
Understood, Your Lordship. Even the Frank White's case talks about that only, which my co-counsel will brief upon. The council requests the bench to kindly peruse through the statement of jurisdiction of the respondents. They have invoked only Article 32 under civil jurisdiction, Your Lordship. And they have not invoked Article 136. And invoking 136 is necessary to argue on issue number 2. We humbly submit to the jurisdiction of the court, but however, it's just a point to be noted which the council is trying to state. If there is no further grievance, then
Not as of now. Yeah.
much obliged, Your Lordship. The council will call upon her co-counsel to deal with issue number 2. It was an honor arguing before this bench.
Please.
No, just answer one thing. See, your case was already you are under. It's a high security prison. It's a high security. It's a high security prison, and then you are already under surveillance, and therefore installing this AI CCTV cameras will prejudice you. So you are already under surveillance. So what is wrong in having an extra? This is only an extra precautionary thing that they are doing. So how does it prejudice you? You admit that you are already under surveillance, strict surveillance, being a high-powered prison. So how do you overcome that?
Much obliged, Your Lordship. The council number 2 deals with the issue number 2, that is regarding the bail condition. Issue 1 was dealt by my learned co-counsel. So answering your question, firstly, when Walter White was in the prison, whole prison was under the CCTV monitoring. And the government of the respondent have also incorporated the AI-powered CCTV cameras in all the prison inmates, where inside the cells also, excluding the washroom and all. But what we are contending, that was against the right of privacy. And after that, when the prima facie case was not proved, the Delhi High Court have granted me the bail, and a bail condition was imposed upon me that I will share the live location of mine to the SHO at all times, 24/7. But this condition is the violation of Article 21, that is the right to privacy, which in my argument, under issue number 2, which I will be dealing with. So with the permission of the bench, I would like to begin the issue number 2. Much obliged, Your Lordship. The counsel for the petitioner humbly submits that sharing of live location to the SHO at all times as a bail condition infringes upon the right to privacy under Article 21. For the benefit of the bench, the counsel would like to present...
Repeat that, please. Could you just repeat that? What is it?
The counsel for the petitioner humbly submits that sharing of live location to the SHO at all times as a bail condition infringes upon the right to privacy under Article 21. So for the benefit of the bench, the counsel would like to present his arguments in two-fold manner. So in the first fold, I will be dealing with this lack of necessity and overbreadth. And secondly, this is a disproportionate infringement on my rights and dignity. So with the permission of the bench, I would like to begin with the first fold of my argument. Much obliged, Your Lordship. So this case has already been dealt. The question of law in this case has already been dealt in the previous case called Frank Vitus versus NCB. So in that case, to summarize the facts of that case, there was a foreign national. He was from Nigeria. So he entered into India and he was charged under NDPS Act for doing illicit drug trafficking. So after that, when the matter went to the Delhi High Court for bail, one of the bail condition that was imposed on his case was that he will share his live location to the SHO 24/7 while he is granted bail. And second bail condition was granted, that was he will obtain a certificate from the High Commissioner of Nigeria that he will not leave the country. And both these bail conditions were set aside by the Honorable Supreme Court. And to substantiate more my point, what the Supreme Court in the ratio decidendi of his case has held.
Could you just refer to the citation, please?
Yes, Your Lordship. Your Lordship, it is the special leave petition criminal number 6339 to 6340 of 2023.
23.
Yes.
You don't have a citation.
Citations. Your Lordship, citation is being given in page number 161 of the compendium. The whole judgment is being attached there.
Is there any harm in just letting us know the citation?
Page 1.
You have just given us one copy. I can't keep troubling.
Yeah, page number 161 of the compendium.
Counsel, in frank witness, what is the nature of allegation against the person who obtained bail? What is the nature of allegation?
So much obliged, Your Lordship. So in our case, the charge
No,
sheet,
no, in frank witness, I must.
in the Frank Whiter's case, the nature of allegation was that he was charged with the NDPS Act. And for the section 27A of the NDPS Act for the illicit drug trafficking in the India. So he was charged with that under the special law. And when the matter went to the Delhi High Court granted two bail conditions. One of the bail condition was that he will share his live location 24/7 to the SHO. And second bail condition was that he will obtain a certificate from the Nigerian High Commissioner that he will not leave India while granting the bail. And both these bail conditions were set aside as unconstitutional. So for that, in page number
Was he accused of being a drug kingpin?
Like in this case?
No, Your Lordship. But he was accused of drug trafficking in that case also, and it was considered as a grave offense also in that case. And when that matter went up to the Supreme Court held
What was the bench strength?
it was a single bench judgment.
Single bench.
Supreme Court single because
Yes, Your Lordship. It was a
Can't be
there are
single
no
bench.
A bench of two judges.
Anyway,
Judge
two
Mohit
judges,
Dayal.
right?
Yeah.
So we can overrule if we.
Yes, Your Lordship.
Okay.
But I will argue on the merits of the case, of my merits. Sure. So if constant vigil is kept on every movement of the accused released on bail by the use of technology or otherwise, it will infringe the right of the accused guaranteed under Article 21 of the Constitution, including the right to privacy. And the reason the Supreme Court gave in this case, the reason is that the effect of keeping such constant vigil on the accused by imposing drastic bail condition will not amount to keeping the accused in some kind of confinement even after he is released on bail. Such condition cannot be a condition of bail. So for that, before coming towards this conclusion, in page number 161 itself, the Supreme Court started with that sentence, we are dealing with a case of the accused whose guilt is yet to be established. So long as he is not held guilty, the presumption of innocence is applicable. So in our case also, as per the MOOT proposition, yes, sir.
Here, that analogy cannot be used in a case of special enactments which carries a concept called presumption. Under the NDPS Act, you are presumed and you shall prove that you are innocent. The law doesn't expect otherwise. It doesn't put the onus on the state to prove that you're guilty. The onus is on you.
Yes,
So
Your
you
Lordship.
cannot draw that analogy in this.
Yes, Your Lordship, but the analogy was created by the Honorable Bench itself in that
No,
case.
it could not have. We'll go through it.
Yes, Your Lordship. Moreover, certain charges was imposed upon me. As per the section 37, which talks about the bail condition in the NDPS cases. So there are certain conditions that have to be satisfied before granting the bail. So bail will only be granted if the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and he is not likely to commit any offense on bail. So both these conditions were satisfied before granting me the bail, that I am not guilty of the charge sheet, the offense that has been imposed upon me, and also while if I will be granted the bail, I will not commit that offense. Even under the UAPA charges, section 17 and 18, which talks about funding of terrorist organization and the conspiracy of promoting the terrorism. So under section 43, clause D5, the proviso of the bail condition under UAPA, bail will only be granted if court is of the belief that there exist no reasonable grounds for believing that the accusation against such person is prima facie true. So in my case, there were no reasonable grounds, and when the Delhi High Court was dealing with the case, there were no reasonable grounds to believe that the court will come to an opinion that this case is prima facie true. So first of all, under Delhi High Court, this case was not at all proved as a prima facie case. And secondly, I was not proved guilty under the section 37 of the NDPS Act.
What are the conditions under 37 that has to be satisfied while considering bail?
Pardon, Your Lordship.
What are the conditions, twin conditions,
Under?
that needs to be satisfied under section 37 of the NDPS Act?
Yes, Your Lordship. The first condition is that the public prosecutor must have been given opportunity to be heard. Second, the bail will only be granted if the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and he is not likely to commit any offense on bail. So all these conditions were satisfied in the Delhi High Court. That's why I was granted the bail. So no prima facie case is against me.
Sorry to interfere, Your Honor, Counsel. Here it does not mention that he was granted bail on merits. So he could have granted bail under 167 class 2 also. So since the prosecution has not filed the charge sheet within 90 days, he could have let on bail. So it need not come under, as per Sir said, the judges was telling, it will not come under part 1 or part 2 of the NDPS Act, 37 of the NDPS Act.
Yes,
So you must make it clear.
Yes, much obliged, Your Lordship.
Now that you are granted, fine.
Yes. So, and as to answer your question, Your Lordship, NDPS is a special law where the negation of a bail is a rule and granting of bail is exception. So whenever a court is granting the bail, the court have to satisfy certain conditions. So these conditions were satisfied. In my case, that's why I was granted the bail.
Not necessary. When the charge sheet is not filed within 90 days, the accused should be granted bail.
But in our case, charge sheet is being filed, Your Lordship.
Counsel, in principle, don't you see why your argument can actually be against fundamental rights? Because your entire argument is premised on bail being a binary. Either you get bail, you don't get bail. We are actually exploring a third option here where you get bail, but under certain conditions. Those conditions are meant, in fact, for us to be more liberal-minded in granting bail. We too don't want everybody to be in prison all the time. But if there is a situation where a person can be taken out of prison, but at the same time, the executive has the confidence that the person will not flee the jurisdiction, and this is a great via media, why can't we explore that via media?
Much obliged, Your Lordship. First of all, to answer your question, this was the same contention raised by respondent in Frank Whiter's case also, but that was not taken into consideration. After Frank Whiter's case, there was one more case where this Frank Whiter's case was being discussed. It was the Sheikh Javed Iqbal versus State of UP. That is in page number 134 of the compendium, where the serious charges of IPC and UAPA was attached to the accused. So in that case, the court referred the Frank Whiter's versus NCB case and held that we are dealing with a case where the guilt is yet to be proved and no live location sharing can be given because it is already held unconstitutional under Frank Whiter's, and bail condition cannot be excessive. So alternatives of that live location sharing was given by the Honorable Supreme Court. So consequently, we passed the following order. The impugned order dated of the High Court is set aside and caused. Appellant is directed to be released on bail subject to fulfillment of the following condition. The condition of sharing of live location was not taken into consideration, and these alternatives were taken into consideration. Firstly, appellant shall not leave the territorial jurisdiction of the trial court. He shall furnish his address to the trial court, and additionally, in addition to the above, the appellant shall mark his attendance before the police station, which the trial court may indicate once in every fortnight till the conclusion of the trial. So rather than imposing a very harsher bail condition, that is sharing of my live location 24/7 to the police station, the court adopted an alternative mean. That is, in addition of the above, I will mark my attendance to the SHO every fortnight. And just after the Frank Whiter's case, there was one more case that is named as Mohammed Tahir versus State of NCT of Delhi. That is in page number 124 of the compendium. In this case also, UAPA charges, terrorism charges, and heinous IPC charges was attached. But while granting bail in this case, Honorable Supreme Court remarked, I pondered over whether to issue a direction to the petitioner to share his real-time location with the investigating officer, but in the view of the pronouncement directly on point in the case Frank Whiter's versus NCB, I am not so inclined. So the court refused. After Frank Whiter's versus Union of India, the court is implicitly affirming that such rights can be infringing upon the right to privacy. There was a case regarding the Supreme Court Legal Aid Committee where there was orally remarked by the honorable bench that such condition can be excessive and can be violative of Article 21, that is the right of privacy.
Yes. So all these rights emerges from Article 21. And it very well says that except according to the procedure established by law. Which case law says about what is the reasonableness of the procedure established by law?
Yes, Your Lordship. First of all, Maneka Gandhi Union of India is that where the procedure established by law has been uh, explicitly discussed in that case. But moreover, here there is no procedure established by law. Sharing of live location, if I will further substantiate, it is in Section 29 of the Model Prison and Correctional Services Act 2023, use of electronic tracking devices on prisoners, which says prisoners may be granted prison leave on the condition of their willingness to wear electronic tracking device for monitoring the movement and activities of such prisoners. So it says prisoners will be granted leave from the jail on his willingness. But the law says that the prisoner, the accused, have to be willingness of wearing those electronic devices. And moreover,
Wearing
there,
electronic devices.
Yes.
It's wearing electronic devices.
yes, like it was indirectly talking about GPS tracking at all. And there was a report by the Standard Committee report by the Ministry of Home Affairs that is being attached in page 149 of the compendium. It talks about, it highlights that however it is may raise human right concern, the committee is suggesting using this method after securing consent from the inmates. So in
It
both
is for
the,
wearing electronic device.
yes,
The consent is needed when the prisoner need to wear any type of electronic device.
yes, but to monitor his movement when he is granted leave from the prison. That is the only
Can you
statute.
relate this with the situation what's happening in these facts?
Yes, Your Lordship. Before Frank White's versus Union of India, such onerous bail condition would be applied if the case falls under a special circumstances. But after Frank White's versus Union of India, this, until the date I am arguing before this bench, this onerous bail condition has not been imposed in any of the cases, either in the TADA cases or the UAPA cases or the Arms Act cases and even in the NDPS cases also. In the recent case of Ankush Verma, where the narco-terrorism charges and the IPC charges and the NDPS charges was also attracted, but in that case also no live location sharing was also allowed, because the court is of the view that such sharing can be onerous, because as per Sanjay Chandra versus CBI, the court rightly pointed out until the liberty of the accused will only be taken away till he will be proven convicted. So till he is not proven guilty.
Just restrict yourself to those who are not natural citizens of this country. Now you're talking about a Nigerian. Walter White is a Nigerian? Or is he from some other country? Whatever country may be. He's not an Indian, definitely. So the moment he's released on bail, is he allowed to go scot-free, walk around wherever he wants to go, apart from the usual condition of signing in the morning, signing in the afternoon, signing in the evening? Or he'll be placed under a camp, which is meant for foreigners who have no liberties as such to roam freely? Now, what is your take on that? What is that you have prepared?
Much obliged, Your Lordship. This kind of scenarios were already predicted in the Karan Singh versus state of UP and others.
Karan Singh is again an Indian.
Pardon, Your Lordship.
Karan Singh is an Indian, I guess. Now, we'll restrict you can restrict yourself to the cases relating to foreigners and situations,
Yes.
contingencies arising out of dealing with foreigners.
Yes, Your Lordship. First of all, foreigners also have the right under Article 21.
They do have the rights. Yeah.
Yes. So in that case also, in the Frank White's case also, he was a foreigner itself. And there was a possibility that he will abscond. And also there was no authority from the High Commissioner of Nigeria that he will not get in abscond. And this two onerous bail condition was imposed upon him. And that was held unconstitutional because even foreigners have the right under Article 21.
No one is questioning that. No one is disputing that. But the question here is, you are dealing with a criminal. According to your proposition, he is the kingpin. Is that right?
Yes, Your Lordship.
What's the word used?
Yes. Lord of the drugs.
Yeah, Lord of the drugs. Much more bigger in nature. So the state has got every reason to object the grant of bail, on top of which he was granted bail by the court. After considering the twin conditions, satisfying the twin conditions, he's been granted bail. Now, what is the prejudice cost to you? Because for every plea that you take, you have to prove the prejudice, what kind of a prejudice is cost to you. So what is the prejudice that is cost to you because you've been asked to pin drop your location to the local SHO. You are being prejudiced in general, the rights have been violated. What is the prejudice? Fundamentally, just give me one.
Yes, Your Lordship. There are many that has been
Just give me one.
that has been illustrated in a case that I will tell. If a man is shadowed, his movements are obviously constricted. He can move physically, but it can only be a movement of an automation. How could a movement under the scrutinizing gaze of the policeman be describing as a free movement? The Supreme Court is asking in a judgment itself. And the Supreme Court further states, the petitioner under the shadow of surveillance is certainly deprived of his right of this freedom. He can move physically, but he cannot do so freely, for all his activities are watched and noted. The shroud of surveillance cast upon him perforce endanger inhibition in him, and he cannot act freely as he would like to do. And one analogy was created by the Honorable Supreme Court. Now suppose there is a prisoner, and suppose his wife have come to meet him. And if I place a guard in front of them, police guard, will they be able to express themselves? The analogy was that on the same ground, will they be able to express themselves? The Supreme Court noted they will not. There will always be it is not a physical confinement, it's a mental confinement, that I will not be able to express myself, I will not be able to move myself, I will not be able to meet someone whom I want to meet. Every movement of mine is being monitored 24/7 by the police officer. So is it not a right? Right to privacy means I can move everywhere freely. I have the liberty. I have my liberty under Article 21, which is an intrinsic right. So that is why in the Frank Whiter's case also, in the Khadak Singh case also, such surveillance.
These rights are not absolute rights. These rights are not absolute rights. Restrictions can be imposed, basically when he is a prisoner.
But he's out of prison and he's not even being convicted. In August 2023, the charge sheet was filed and I was arrested on that day. And I am arguing this case today on 5th April 2025. It is nearly 2 years, and this case, the charge sheet is so probative that my charges had not been proved yet. That is why the time has passed. The charge sheet is so...
When were you arrested? March of?
Is August. It's in the MOOT proposition, paragraph 6. In August.
March 2023, you were arrested.
Yes, Your Lordship.
Your arrest is based on an FIR.
Yeah, no, it was just a periodic check-ins like they were doing to the NDPS accused. And after that, I was arrested after that.
Even after a periodic check, unless an FIR is registered, you cannot be arrested.
No, Your
law.
Lordship.
That is law. That is law. Because your arrest card must contain the crime number, right? So that is the principle. So you said the charge sheet was late. When was the charge sheet late?
Even in the clarification 3 of the, clarification 2 of the MOOT.
Where? Take us through your memorial.
We state that charge sheet is being filed.
Where do you get it?
Clarification 2.
What are the charges against Mr. White? Charge sheet filed by the prosecution wing of the state, so and so, so and so, so and so.
When it was filed? That's my question. That's the question.
That is not there.
First of all, I was arrested because there was a hardened drives that were going on, like to catch and the NDPS drug peddlers. And after that, I was arrested. There was no FIR was registered against me. And they prepared a charge sheet and submitted to the Delhi High Court. And after that, no.
Let us go by the established procedure under law. A person cannot be arrested without a case being registered against him. He did not be named in the FIR, but There'll be some FIR or the other, where based on a confession leading to a discovery of a fact, that would lead to the arrest of another person. So never ever say that there was no such FIR, but you were just arrested arbitrarily. Then your remedy is not here, it is elsewhere, right? Only on an FIR, a person can be arrested in every other situation that can be imagined and thought
Yes,
of.
much obliged. But the moot proposition was silent on that
You
fact.
should have first asked that, whoever prepared the proposition. Okay, anyway, fine.
I will just need 30-second time to
Please
wrap it
take
up.
1 minute.
Yes.
We are very magnanimous.
Yes, much. And after just Frank Whiters versus Union of India case, there was one more case, Jalauddin Khan versus Union of India, where such bail conditions were also discussed. In that case, heinous charges of IPC and UAPA was put, but there was no prima facie case. So the Supreme Court held that no such conditions can be put, sharing of live location. It is against the right of privacy under Article 21. And moreover, in various cases, again, I will make an analogy of the Srimati Selvi versus State of Karnataka. That is a very landmark judgment of the Honorable Supreme Court regarding the polygraph testing. And in that test, in paragraph 193 of that judgment, it is held, therefore, it is our considered opinion that subjecting a person to the impugned technique involuntarily violate the prescribed boundaries of privacy. In such cases, he or she could still face adverse consequences such as custodial abuse, surveillance, and undue harassment and social stigma, among others. And such conditions were termed as cruel, inhuman, or degrading treatment. So in my case also, the Supreme Court is saying you are applying the polygraphic test. What if he is not convicted after that? He has already gone the adverse consequences, the custodial abuse.
How can you draw an analogy between a polygraph test and somebody asking you to drop pins on your locations to the station house officer?
Much obliged, Your Lordship. That's why.
Because in general, a general condition on a grant of bail would be to appear before the respondent police twice daily or thrice daily, even 4 times a day. It is a normal condition. All you have to do is pin drop your location to the station house officer. This is where I am, just to make sure that the station house officer is aware of where you are. Nothing more. It doesn't mean you draw an analogy with the case law where a policeman stands wherein a husband and wife want to express themselves. So dropping one's location with the station house officer, how can that be compared with a situation like this? All you have to do is, look, this is where I am. Take your location, send a WhatsApp message to him, that's all. All just to satisfy the station house officer that you are here within his vicinity, that's all. In what way that prejudices your cause? Because the analogy that I asked for one instance of prejudice, and you gave me an instance by saying that, what if my wife comes running to hug me?
So that analogy was given by the Honorable
Fair
Bench.
enough,
itself.
we are from the Supreme Court of India now, not from India. So we can ask questions.
Yes.
Yeah.
Yes, Your Lordship. Moreover, first of all, like rightly pointed out by the Honorable Bench, that it is not just a physical confinement.
So
It is
go beyond the scope of the judgments.
Yes.
See, the thing, you cannot keep reiterating what the Supreme Court had said. So you are before a larger bench of a different country altogether. We want some kind of an individuality, some kind of a creativity from you. We don't want something to be repeated what the Supreme Court has said. That's what we are looking for.
Yes, Your Lordship. So for me, there's a confinement in my mind. Like whenever
So
I'm
it's a mental confinement.
it's
the
a mental
prejudice.
confinement.
Fine.
Whenever I'm going somewhere, my all movements of mine are being monitored 24/7, even after when no prima facie case was proved against me, and there was a reasonable grounds before the Honorable High Court that I'm not guilty of the offense that is being charged upon me, and whenever I will be granted bail, I will not commit those offenses. And moreover, I fulfill all the conditions that is being given by Sanjay Chandra versus CBI. The principle decided by the Honorable Supreme Court in this case, the evidence quality have to be judged. There was no evidence quality in my case. That is why there was no prima facie case that was.
When would the word evidence be used? What is evidence? In a
Evidence,
strict sense.
in a strict sense, which evidence is something which proves my offense, like which adds upon
When would that word evidence would come into play?
in a trial phase.
During the course of trial.
Yes.
Have you faced trial yet?
No, Your Lordship, but this is being dealt while granting the bail to me. And moreover, like one more bail condition was one more principle that have to be taken care of. That is risk of absconding or tampering. I am a foreign national. That in the Frank White's versus NCP case, in that case also the accused was a foreign national. But confiscating of his passport is a less intrusive mean rather than just putting a 24/7 surveillance upon him. And
Do you know in India you can take a fake passport within 30 minutes?
that is the procedural irregularities.
No, I'm talking about a fake passport, not a genuine one.
It can be taken.
Yeah.
But,
So what's the big point taking your passport from?
but even that, if that analogy will be applied in my case also, I can keep my phone here itself. That will show location of mine to this moot court hall itself, and I can go outside and flee from this country itself.
He's already thought of ways.
We don't want you to do that.
But if that analogy would be applied, every bail condition can be misused, is what I'm saying. Every bail condition has the probability that it can be misused. Because in the Frank White's case, there was no surety that who will put a bond surety upon the accused that he will not leave the country, he will not abscond the country. And the Supreme Court held that it is not upon the High Commissioner to give the confidentiality and to prove that he will not leave the country. Even after that, he was granted the bail in that condition owing to the right to privacy under Article 21. So in the same thing I am demanding in my case, where I am also a foreign national, and after Frank White's case, sharing of live location and continuous surveillance as a bail condition is declared unconstitutional. Even after declaring unconstitutional, this same bail condition was imposed upon me. And moreover, there is no prima facie case against me has been proved yet. And also there is no reasonable ground the Honorable Court has reached till now that I am found guilty of the offense that I have been put upon in the charge sheet, and I will not commit those offenses. If the less intrusive means are available, like confiscating my passport, and I can periodic check-ins to the SHO every fortnight, presenting my presence, as Sanjay Chandra rightly stated, that the bail is not, I just need 30 seconds time. Bail is not a preventive or prohibitory. It is just a means that the accused who is granted the bail will ensure his presence in the next trial process. So that is just, I'm ensuring that I will...
From where do you get that? Grant of bail means to ensure your presence in the trial proceeding. Who tells you that?
It is in the Sanjay Chandra versus CBI case. I will read the relevant provision. The object of bail is neither punitive or preventative. Deprivation of liberty must be considered a punishment unless it is required to ensure that an accused person will stand his trial when called upon. The courts owe more than verbal respect to the principle that punishment begins after conviction and that every man is deemed to be innocent until tried and found guilty. So as of now,
Again and again, you go to the settled principle of deemed to be innocent until proven guilty. Here is a case where there is a presumption, though you are granted bail after satisfying the twin conditions, you are still an under trial prisoner, you have been accused of an offense under the NDPS Act. You have to face the trial, right? So that judgment says the bail was granted to enable you to attend the trial. They can always keep you inside the prison and still they can force you to attend trial. There's no bar. Bail is not meant for that. It is the benevolence that is extended.
yes, much obliged, Your Lordship. But in the further case also, in 2025 itself, in the Sheikh Iqbal case and in Mohammad Tahir case, UAPA charges and TADA charges was also attached. But court refused to put sharing of live location as a bail condition because it is against the right to privacy under Article 21. The court would have taken this stance under the interest of justice, but the court refused because such condition is against the right of privacy. In the it's the settled principles. In nowadays, onerous bail conditions are only granted under special circumstances, as reiterated in Muralitharan case, and not in the course of time.
So the proposition says the matters are now set for a final hearing before a 5-judge constitution bench of the Supreme Court of India.
Yes, sir.
So we have the powers to unsettle it. So to unsettle it, you cannot cite citations, which is rendered by a bench of lesser strength and say these are all things you have to follow. So there are 5 of us, 5 minds are going to think, and you have to come forward something which is unique and which is from you, not from the benches. Anyway, the time's up. I think we want another 30 seconds?
30 seconds more.
Go.
So, first of all, Your Lordship, as per case Puttaswamy case, I understand there is a legitimate state aim that they want my live location because there is a presumption, there's a presumption that I might abscond from this trial process. I might go. And it might be sanctioned by law under relevant provisions of CRPC as stated in Frank Whiter's case, section 437, clause 3, in the interest of justice. But again, it doesn't fulfill the test of necessity and proportionality. So whenever, in the modern dental case also, it was discussed in Puttaswamy case by a 9-judge bench judgment, whenever you are curbing anybody's right to privacy, the 4 tests have to be fulfilled. And in the modern dental case, necessity and suitability was one of the conditions, and the alternatives also was one of the conditions that have to be fulfilled when you are putting restrictions on somebody's fundamental right. And whenever, in the modern dental case itself, if lesser intrusive means are available, you will not impose higher intrusive means to curb the right of fundamental rights. So in my case, what I am contending, where the lesser intrusive means are applicable with the same suitability and with the same necessity, then why I am not imposed to those bail conditions rather than I was applied a higher intrusive bail condition, which is already declared unconstitutional. And after Frank Whiter's case, no case is there which have used the life-sharing location mechanism. So based on that, with the permission of the bench, I would like to begin my prayer.
See, I think both the speakers have lost the fact. I mean, I'm not trying to say anything. You're not prejudging. See, the proposition says, as I just want to repeat it, you're before a 5-judge constitution bench to test the validity of whatever that's already been rendered. Under such circumstances, you cannot force us to look into the judgments, or it is only persuasive. So to be something more than that, you have to come forward with some kind of an original thought process that would prevail over us. No, merely you want us to go through the judgment of victors, Frank Victors and Puttaswamy. Puttaswamy is different. So go a little further, be original.
And just adding to my brothers, see, you are relying heavily on this Frank Victors case, right? In Frank Victors case, the Supreme Court has relied on the judgment in State of AP versus Challa Ramakrishna Reddy, right? If we distinguish this case from the facts of Challa Ramakrishna Reddy, and we decide to deviate, then how will you justify your presentation?
Yes, much obliged, Your Lordship. First of all, in the state of AP versus Challa Ramakrishna Reddy, where it was held that until and unless the guilt is being proved, my right to liberty is with me. So,
you know the facts of Challa Ramakrishna Reddy?
Pardon, Your Lordship.
The facts of the case were that the son and father were in prison, and there was a riot or something in the prison. A bomb was thrown into the prison. The father died, the son sustained injuries, and the family thereafter, they filed an application before the court for compensation. So if we apply the ratio of the case to the facts of the case, then how do you justify the ratio as far as the facts of your case are concerned?
Yes,
This is what I think my brother wanted you to explain.
Yes, much obliged, Your Lordship. In both the cases, as you have rightly pointed out the facts of the case, in both the cases, the guilt was not yet proved. In my case also, the
No,
guilt...
it's not a question of guilt. It was a case for compensation. Where is the question of guilt? It was against the state that they filed the compensation application.
Yes, but compensation will be given when the state will be proved guilty of the...
No, it is something which has happened within the precincts of a prison which is maintained by the state. Anyways, I won't trouble you.
So with the permission of the bench, I would like to begin the prayer. So wherefore, in the lights of facts presented, issues raised, argument advanced, authorities cited, the counsel on behalf of the petitioner humbly prays before this Honorable Supreme Court that it may please to declare, construe and restrict the installing of to the common areas, but not in barracks and cells, declare that the imposition of the condition that Walter White will share his live location with the SHO of the local police station at all times while being on bail is a violation of his right to privacy, or pass any other order that the court may deem fit in the light of equity, justice, and good conscience. And for this act of kindness of your lordship, the petitioner shall as duty bound ever pray. Much obliged, your lordship, and it was pleasure arguing before this meeting.
If it pleases the court, your lordships, the council seeks permission to collectively address the benches, your lordship. Much obliged, your lordships. The council is here in the matter of Walter White versus the state of Indiana on behalf of the respondent. With due permission of the bench, the council seeks permission to proceed with the arguments. Much obliged, your lordships. The council will be dealing with the first issue, while my co-counsel will be dealing with the second issue, followed by the prayer, and we have reserved 3 minutes for rebuttals. Your lordships, the counsel for the respondent submits that under Article 19, Clause 2 of the Constitution of Indiana, the state is authorized to impose reasonable restrictions on fundamental rights to safeguard public order, national security, and the rights of others. Your lordships, in the present case, the installation of AI-powered CCTV cameras in prison is a necessary and proportionate measure to ensure the safety of both inmates and the staff, particularly in the light of the petitioner's high-profile status. Your lordships, this is because the state's responsibility to maintain order, discipline, and security within such institution outweighs the individual's right to privacy. Your lordships, the council would like to quote the case of Justice K.S. Puttaswamy and another versus the Union of India, which my learned counsel for petitioner has also mentioned. The Supreme Court established that the right to privacy is a fundamental right under Article 21 of the Constitution. The council has no dispute with that. However, your lordships, the council seeks to establish that the court outlined a three-pronged test to evaluate any infringement upon this right. Applying this framework to the case at hand, your lordships, the installation of AI-powered CCTV cameras in prisons meets all three criteria. With respect to legality, your lordships, the deployment of the surveillance measures is authorized by existing laws governing prison administration and security protocols, such as the MPCA, which is the Model Prisons and Correctional Services Act 2023, and the NSA, which is the National Security Act. Your lordships, with respect to legitimate aim, the primary objective of the state is to enhance the security within the prison system and prevent the criminal activities such as drug trafficking and terrorism and protect the rights of inmates and staff. Your lordships, the council, as the learned counsel for petitioner has also mentioned in their memo, with reference to page 13, paragraph 11, third line, as the measure of installation of CCTV cameras is directed by the Supreme Court itself, the same satisfies the first test of the authority of law, which the learned counsel for petitioner has also agreed. Your lordships, with respect to the second test, your lordships, the second test requires that the measure should be a legitimate aim. the learned counsel for petitioner also agrees with that. However, your lordships, in paragraph 13, the learned counsel has stated that there is no proper justification as to why security cameras are the only proportional and direct solution to the problem of human abuse and custodial deaths in prisons. Other means such as stricter rules and regulations, more effective implementation of already existing rules and regulations can be used to find the solutions to the problem has been mentioned by the learned counsel for petitioner. Your lordships, this imposition of this measure, this AI CCTV camera measure is AI CCTV camera is installed to be a less excessive measure. Your lordships, with reference to section 2 of the Model Prisons and Correctional Services Act, yes, your lordships.
First and foremost, what is the primordial objective of installing an AI-powered CCTV camera? What exactly does the AI-powered CCTV camera monitor?
Much obliged, your lordships. Your lordships, the use of AI-powered CCTV camera is that when the prisoner is going beyond a certain extent of the perimeter within which he is supposed to go, the AI CCTV camera would send a signal. Yes, your lordships.
Yes.
The AI CCTV camera would analyze.
I'm going to commence my question. See, it is an high security prison.
Yes, your lordship.
Is it an isolation chamber or an individual chamber, or it is a common? If it is an high security prison, the cells are meant for each prisoner,
Yes, your
right?
lordships.
Why do you have to install an AI-powered CCTV camera inside the cell? There's one on the corridor is more than sufficient.
Yes, your lordships. But with reference to section 5, clause 5, the high-risk security prisoners are supposed to be housed in a separate cell. For instance, your lordships, if there are 30 prisoners in a high-security prison, and if 2 inmates are in one cell, then it is 15 cells for 30 prisoners. But your lordships, considering 30 prisoners are housed in individual cells, it is impossible. It is very hard for manual monitoring. Thus, your lordship, the AI-powered CCTV camera.
Don't you think you live in peace in an individual cell? Why should he be monitored?
But your lordships, with reference to section 20, your lordships, with reference to Model Prisons and Correctional Services Act, all these high-risk prisoners must be monitored continuously.
Monitored.
Because of the threat.
That is exactly what we are asking you. See, what does that AI do? Does it look for facial changes, expression changes, that today is not in a good mood, tomorrow he is planning for something? What kind of monitoring that you want to do? All you want to make sure that he is in the cell.
Yes,
right?
your lordship.
So why do you need a camera inside the cell?
Your lordships, with respect to manual monitoring, it will give with respect to the AI CCTV camera, the AI CCTV camera will analyze, like the council mentioned before, it will analyze the behavioral patterns. For instance, if he moves beyond the perimeter, for example, if
Moving beyond the perimeter of in the prison.
Within the prison cell.
How that show the behavioral pattern of a person? That a normal constable can sit and watch him. He does a better job than the AI.
Your lordships, if electronic gadgets or any contraband is smuggled inside the AI CCTV.
So the state admits that all these things can be smuggled inside.
For transparency reasons, your lordships, just
That an ordinary CC camera can also capture, right?
no. That is the difference between CCTV camera and an AI CCTV camera, your lordships. For instance, your lordships, if there are 2 CCTV monitors, people who are monitoring the 30 rooms of the CCTV, it is better if the AI, if they get the signal that that the prisoner is trying to do something, or if he is trying to commit suicide within the cell. One single person or 2 individuals cannot do what the AI is doing, because every room, every prisoner will be doing a separate thing. AI acts as an additional measure, and it acts as a preventive measure, your lordships.
No, our question is, their issue is simple. They are not objecting to installation of an AI CCTV camera on the corridors. Why do you want to have one inside the cell? That's the only question.
Your lordships, considering this person is a high-risk offender, your lordship, with reference
So you've terming the high-profile prisoner, all those things. Then how was he granted bail? How was he granted bail then?
Your Lordships,
You failed. The state failed to impress upon the court.
no, Your Lordships.
Then, go on.
Bail is a right, Your Lordships.
Bail?
Your Lordships, the
Section
my-
37.
37 of the NDP.
What it
Bail is
says?
not,
Bail
not
is
a
not
right.
right. It's not right, Your Lordship. Your Lordships, with reference to moot proposition, it is mentioned that majority of Indiana's population is poor. However, the first time in its history, over 60% of Indiana's population is below the age of 35. And however, due to the widespread use of drugs and narcotic substances by the youth in several parts of the country, achieving this goal has become a real challenge. Your Lordships, looking at this with respect to a national, in reference to a national security objective, the doctrine of parens patriae can be used. Which means the state has a responsibility to protect the welfare of its citizens, particularly in situations where they cannot protect themselves. This includes protecting the citizens from external and internal threats such as the terrorism and misinformation. Moreover, Your Lordships, the doctrine of implied powers can also be used. This legal principle allows the government body to exercise authority not explicitly mentioned in legislations, but deemed necessary to effectively fulfill its expressly stated functions.
That shouldn't be not in violation of the law established under the Constitution, right? Yeah, it's got powers, even if there is no law laid down. The authorities can
Yes,
impose
Your
certain things, but that cannot be violative of the fundamental rights and the provisions of the Constitution, the articles of the Constitution.
But Your
That is their problem. That seems to be their problem.
Much obliged, Your Lordships. But here the proportionality has to be considered, Your Lordships. The state is a custodian and it must be responsible. Considering with reference to moot proposition paragraph 5, the petitioner is a foreign national. So, the petitioner was under the custody of the state. Thus, Your Lordship, the state is responsible and the state is obligated for the petitioner as well, for housing, for that, because the petitioner is under the custody of the state. If Your Lordship is satisfied, the council 6. Much obliged, Your
We
Lordship.
will not express our satisfaction or dissatisfaction. Don't worry.
Much obliged, Your Lordships. Section 14 defines high-risk prisoner as a prisoner with high propensity towards violence, escape, self-harm, disorderly behavior, likely to create unrest in prison, and a threat to public order, and include those engaged in organized crime and terrorist activities, which is very relevant with respect to the matter in fact, matter in hand, Your Lordships. Moreover, Section 2 also states that high security prison means an independent, self-sufficient prison complex with dynamic and strengthened security systems with provision for an independent court complex, etc., to house convicted and under trial inmates as well, who need to be kept in a high security custody areas, such as person involved in terrorist activities, gangsters, dangerous prisoners, etc. Your Lordships, Section 14 and 15 clearly define high-risk offender as someone with a violent tendencies, a threat to public order, and involvement in organized crime and terrorism. Given this, Your Lordships, with reference to moot proposition paragraph 7,
Whether the petitioner herein falls within the parameters of whatever you have just enlisted,
yes, Your Lordships.
where
With reference to moot proposition paragraph 5, Walter White, an Indian citizen who is also known as Lord of Drugs internationally, the arrest of Walter White, the kingpin of...
whether the word Lord of Drugs would fall within the, whatever explanations you said, self-harm, self-destruct, whatever you just read out.
Yes, Your Lordship, with reference to paragraph 6 of the moot proposition, it has also been indicated he funded narco-terrorism, Your Lordships.
What is narco-terrorism?
Narco-terrorism is illicit drugs being trafficked and distributed within the country, Your Lordship.
Why should they use that word terrorism?
Because it affects the whole country, whole state, whole nation, Your Lordships. And it is against the state. Thus, it can be considered as terrorism, Your Lordships. If
So
Your
you have a
Lordship is
systemic solution here.
Yes,
This
Your
is not to do with one particular individual, even conceding your point that he is a narco-terrorist. There are many others in the maximum security prison. This
Yes,
affects
Your
everyone,
Lordships.
right?
Yes,
All
Your
kinds of
Lordships.
people, some, who are sex offenders, some who
Yes,
are,
Your
thieves or, high-end thieves, so to say, cyber criminals. Everyone is put in a maximum security prison and there is no distinction at all, and you decide that you are going to put in cameras inside everyone's cell. What is the rationale for this one stroke meets all kind of treatment?
Your Lordships, much obliged, Your Lordships. To answer to Your Lordship's question, with reference to Section 27 of the Model Prisons and Correctional Services Act, Clause 2, based on the details of the crime committed by the inmate, available background record, history ticket, etc., inmates shall be suitably classified, assessed for their propensity and potential to negatively influence other inmates, and to be housed in separate barracks and cells as may be appropriate. Your Lordships, thus, Your Lordships,
What's the act?
Model Prisons and Correctional Services Act 2023, Your Lordships.
MPCA.
MPCA Act 2023.
You are saying that it is high security prison.
Yes, Your Lordships.
The safety of the prisoners is safeguarded.
Yes, Your
Then now
Lordships.
you expect them to commit suicide.
Your Lordships, it is an additional measure so that if they try to do something, there are high chances that when a prisoner comes into a prison, when he is admitted into a prison, Your Lordships, he loses his identity. He is given a number. All of this will cause mental trauma. And when, moreover, Your Lordships,
When would the person be given a number instead of calling him by name? Under trial prisoner or convict?
convicted prisoner.
Is he not convict here?
I was addressing to convicted prisoners, Your Lordships. But under trial prisoners will also have mental issues, Your Lordships. The Council 6
Now,
permission.
have you heard the Chennai Central Jail case? You know that? One accused was electrocuted due to the charging of the cell phone.
Yes, sir.
So you're saying that the CCTV camera has been installed. There is chances of electrocuting, So
Your
you have to think
Lordships,
like that.
with the Model Prisons and Correctional Services Act also has provisions related to that, Your Lordships. Section 35, Clause 1, secure walls, building gates, Your Lordships, mostly the prison wall will be built high. So all of those measures are already taken by the state, Your Lordships. The Council...
You went inside the Central Jail, Chennai, Pulal. Not,
No, Your Lordships.
okay, carry on.
The Council seeks permission to continue, Your Lordships.
Carry on.
Much obliged, Your Lordships. Given this, when the petitioner was lodged in a high security prison, what else could he have expected? To suggest he should be without maximum security monitoring is utterly absurd. Your Lordships, under Section 26, Clause 5, Clause H of MPCA Act 2023, which explicitly mandates that high-risk offenders such as the petitioner be placed under the highest level of security. In this regard, Your Lordships, the installation of CCTV cameras inside the prison cells of such inmates is deemed a reasonable and necessary measure to ensure that their confinement does not compromise the security of the prison and the nation at large. Thus, Your Lordship, the Council would like to state this as a counter-argument for the argument presented by my learned friend.
Do we have the power to read down the MPCA?
Your Lordships?
Do we have the power to read down the MPCA?
Yes, Your Lordships. Considering it is the public interest litigation and MPCA Act was passed on 2023, it should be taken in a prospective view.
It's a judgment that came, it's a statute that was passed after Puttaswamy, right?
Yes, Your Lordships.
And Puttaswamy
Yes, Your Lordship,
is a judgment that binds us as well, because the larger bench than even five judges. Correct? So, in the light of what Puttaswamy says, shouldn't we be reading down the powers given to the executive under the MPCA is our question.
The Council will be...
MPCA is passed by the executive. The executive will always, by the legislature of course, but the legislature will always vest maximum authority with the executive. But as sentinel qui, you know what that statement means? Those who protect and uphold the Constitution, that is the role of the judiciary. We have a responsibility to read down the powers under the statute when it goes beyond, the rights of privacy. So is citing the MPCA helpful at all? We may not strike it down, but we can still read down the powers given to the executive. What is the difference between reading down a provision and striking it down, counsel?
Reading down the provision is taking it into consideration before passing the judgment, Your Lordship.
No, it is interpreting the law
Interpreting the
in
law.
such a way that it falls within the four corners of the rights guaranteed under Part 3 of the Constitution. And that is exactly what we propose to do. We can read down all these provisions that you're citing, can't we?
We can, Your Lordship.
Okay. Proceed.
We can, Your Lordships. The Council seeks permission to proceed. Much obliged, Your Lordships. Moreover, Your Lordships, with reference to Section 3 of the NSA Act, which is the National Security Act, and it has to be taken into account, Your Lordships, that the petitioner is a foreign national. This act also empowers the authorities to take preventive actions against individuals who are likely to disturb peace or engage in activities prejudicial to the security of the state or the maintenance of public orders. It reads, Your Lordships, power to make orders detaining certain persons. The central government or the state government may have powers to make orders.
Counsel,
Your
what
Lordship.
about the right of privacy, right of dignity of the foreigner?
Your Lordships.
What about the right of privacy and right of dignity of the foreign
It can be,
prisoner?
much
Under
obliged,
trial
Your Lordships.
prisoners.
Much obliged, Your Lordships. It can be outweighed by the principle of parens patriae, Your Lordships. State
Can you
has a,
substantiate?
yes, Your Lordships. The state has the responsibility to protect the welfare of its citizens, Your Lordships. And when it comes to proportionality, Your Lordships, he is a
My
foreign.
question is, what about the right to privacy and dignity of a foreign under trial prisoner?
Your Lordships, the council has no dispute with the fact that he is a foreign under trial prisoner. But Your Lordships, it has to be taken into account that because of this one foreign national prisoner, the whole state can be affected. Moreover, Your Lordship, it has to be taken into account that over 60% of Indiana's population is youth, and it has been largely affected by the narco-terrorism. Your Lordships, 60% of the population is 846 million people, and he is 1%. Your Lordships, moreover,
Counsel,
the case
everyone
involves-
in the maximum security prison is not a drug lord. We are talking about a system here, right? We are not talking about issue number 2, which is specific to him. We are talking about issue number 1, which is common to all the prisoners in the maximum security prison. So how does this fact have any relevance? 60%, you're talking in the terms of the drug-related offenses.
Your
The
Lordships,
question is installation of AI-powered CC camera in this high-sensitive areas of the prison. Whether these prisoners, under trial prisoners or prisoners, whether they have the right to dignity and right to privacy. How you will substantiate it?
much obliged, Your Lordships. The right to privacy was recognized in the judgment of Puttaswamy versus the Union of India. Your Lordships, the council seeks to establish that all the 3 tests which are mentioned in the Puttaswamy judgment are justified by the state. Your Lordships, in reference to legality, and plus the legislative framework also exists. Your Lordships.
Can you explain that legislative framework here?
Much obliged, Your Lordships. With reference to the data which is the council seeks additional one. With reference to the data which is collected, Your Lordships. Much obliged, Your Lordships. With reference to the data which is collected from the CCTV camera, as the petitioner has mentioned in paragraph 7, where he mentions about the potential cause for data theft, etc. The IT Act 70B mentions about the Computer Emergency Response Team to serve as a national agency, Your Lordships. Thus, Your Lordships, there is proper provision and there is proper authority to proper provision to address this issue. Your Lordships, if Your Lordships are satisfied, the council seeks permission. Continue.
No, her question was, how do you trace your power to impose this restriction, right? That was, to which legislature, statute, guideline, whatever, prison manual, whatever, to which statute do you trace your power to for imposing this restriction? You have convinced us, assuming that you've convinced us on, assuming you've convinced us on the reasonability of the restriction. Now we want to find out the source from which you get this power to impose the restriction.
The Model Prisons and Correctional Services Act, Your Lordships, 2023, which the whole preamble, the whole purpose and preamble mentions about the rehabilitatory and retributive objective, Your Lordships. Thus, Your Lordships, the legislator that can be taken into account, Your Lordships. Moreover, Your Lordships, with reference to AI legal framework, the absence of specific
Which provision of the act you said you're referring to?
Section 70B of the IT Act, Your Lordship.
I'm talking about this. Prisoners.
Model Prisons and Correctional
Which
Services
provision
Act.
of law?
30, provision relating
To the CCTV, installation of CCTV.
Section 35 clause 1 and section 18, Your Lordships. Section 35 clause 1, Your Lordships. Sorry. Section 18 of the MPCA Act states that, Your Lordships, the state shall ensure integration and embedding of appropriate technology, I repeat, Your Lordship, appropriate technology for the effective management and superintendence of the prisons and for the safety and security of the prisons and inmates, which may include biometrics, CCTV systems, scanning and detection devices.
Does it give you the liberty of extending that arm to intrude into the privacy of an individual in an individual cell? That would be the question. Yes, it speaks about it.
Yes, Your Lordships.
Can you place a camera within the cell, an individual cell? Would be the only question. That is their problem too.
Much obliged, Your
It
Lordships.
doesn't specify that. To what extent you can intrude into the privacy of a prisoner.
To address to that question, Your Lordships, the right to privacy is recognized only under the case Puttaswamy versus the Union of India case, Your Lordships.
Counsel, that is completely incorrect. K.S. Puttaswamy recognizes the right, but the right to privacy is inherent, I mean, it's like the classic debate going back to ADM Jabalpur, right? Can the right to life exist or not? But I have a slightly separate question, which is to request you to step back from all these laws that you're citing and simply tell us if there is systemic surveillance of the kind that is authorized by the MPCA, what do you think is a harm to society from a privacy standpoint? In specific, Counsel, I'd like you to address the chilling effects doctrine. Chilling effects is one of the strong reasons why in multiple cases we have struck down legislation that has the potential to make everyone act in a certain manner under the fear of surveillance. A classic example is our own decision in the case of Shreya Singhal. Though not relating to surveillance and relating to the IT Act, the whole idea was that we will all control the way we speak if there is a law that criminalizes a certain conduct. Similarly, coming now to the present scenario, isn't there a strong possibility that these prisoners, who as it is have limited rights inside the prison, are going to even constrict their rights further from what they should ideally be enjoying, simply because you have put in place a mechanism, a system of surveillance using your powers under these various enactments? Does that not lead to a kind of chilling effect?
Much obliged, Your Lordships. Your Lordships, in the case of Upadhyay versus the state of AP, the prisoner's rights are restricted. It was stated that the prisoner's rights are restricted in order to prevent misuse of the right they already have and ensure the security of the prison and society at large. Thus, Your Lordships, they might have the right to privacy. The counsel for the petitioner may argue, saying that right to privacy is the right to privacy is essential. But Your Lordship, however, it is not absolute. If the prison rights can be restricted with respect to the council seeks an additional 1 minute to summarize, Your Lordships. Much obliged. The rights of the prisoners can be restricted in order to prevent the misuse of the rights which they already have, Your Lordships. That only by restricting those rights, we can prevent the in ground realities, your lordships, the council, the prisoners have privacy in most of the prisons, but that is one of the very reasons why there are he might go there are high chances that the contraband might enter the prison, or inmate fight, etc., your lordships, or the prisoner. Moreover, your lordships, custodial death has to be taken into account. The prisoner,
That
it is
should be
to prevent.
prevented in, that should be prevented in the entrance of the prison itself.
Your lordship.
Why the question is why the CCTV is installed inside the premises of the prisoner? That is the main question.
Much obliged, your lordships. It is also to protect his right to life, your lordships, because there are high chances that the prisoner might commit suicide. This is one of these measures act as a preventive measure to prevent.
That is the duty of the government to the police authorities to check them. It is the duty of the authorities to check them whether they are having any instruments to commit the suicide or so. So you should take measures to prevent them from committing suicide.
Your
So
lord,
how long does it take for a man to slash his throat?
Yes.
2 hours? Just a second. That's all.
Yes, your
Time
lordships.
taken to run through your thing. So a person watching from the surveillance room, seeing the CCTV footage, has to run all the way from there, go there. By the time he is dead and gone, what way is going to be prevented?
Your lordships, but there is also, to answer to that question, your lordships, there is also a higher chance of saving the life of that person, your lordships, because the main objective of AI powered CCTV cameras is to send a signal. Through that signal, your lordship, whichever guard is near to that prison, your lordship, will be alerted so that immediate action can be taken.
So, counsel, you're saying there are no psychological effects at all on a person or a group of persons who feel that they are being constantly watched by an AI-powered CCTV camera? Does that not drive people to suicide, even in certain cases?
Much obliged, your lordships. To answer to that question, your lordships, the fact that he is a high-risk prisoner cannot be taken easily, your lordships, because the MPCA Act also addresses about the mental health of the prisoner, your lordships, with reference to section 45 of the MPCA Act. Mental health and psychological assessment can also be done, because, your lordships, there might be prisoners who are lunatics, or if the CCTV camera if the AI intelligence camera analyze.
Are the lunatics housed inside a prison?
Your lordships.
Are the lunatics housed inside the individual prison cells or the high-risk cells?
If the prisoner, when he is admitted into the prison, was in the normal state, and he might get affected by
So you
various.
mean to say he is abandoned for the rest of the few days before he is diagnosed with lunacy, mental illness? Is that what you're trying to convince?
Much obliged, your lordship. No, your lordship, because these these AI-powered CCTV cameras can be used to analyze his behavior.
That is exactly why the first question at the inception that I asked you was, what does the AI do?
What does it do?
I asked you whether it recognized your facial expressions and all those things.
Yes.
They weren't answer at that point in time. Every time this gentleman gets up, I become conscious because I'm being monitored by that camera. So he just now got up. He was sitting all the way. So that's the state of mind that you are in. You know, you tend to be more conscious when you're monitored.
The question is, what will be the psychological effect of 24 hours surveillance?
Your lordships, the psychological effect for the prisoners as a whole, your lordships, if no CCTV cameras are installed inside every inmate cell in the whole high security prison area, your lordships, this can pose a high risk for the security of the staffs as well, your lordships. That has to be taken into account, your lordships. If the council seeks permission to proceed. Moreover, your lordships, Moreover, Your Lordships, the Council seeks to quote yet another case of Bikash Duria versus. The Council seeks additional 1 minute to conclude, Your Lordships. In the case of Bikash Duria versus the state of Odisha, Your Lordships, it is mentioned that compendium, with reference to compendium page number 5, Your Lordships, it is mentioned that addiction is like a curse, and until it is broken, its victim will perpetually remain in the shackles of bondage. Your Lordships, this is very well relevant to the matter in hand. Your Lordships, while articulating the danger of the issue at hand and its ripple effect, the fugitive smuggling and trafficking of drugs is linked to a host of social ills, including the involvement in crime, destabilization, and decline in family relationships, kingships, etc. Your Lordships, thus, the Council would like to conclude by saying that the installation of CCTV cameras inside the inmate cell is not just justified, it is a moral imperative, Your Lordships. Indiana's youth, over 60% of the population, face an existential crisis due to the rampant drug abuse and criminal activity with reference to MOOT proposition paragraph 2. Thus, Your Lordships, the state cannot afford to sacrifice the future for the privacy of individuals who threaten the safety and well-being of the nations. If Your Lordships are satisfied, the Council seeks permission to let my co-counsel continue with the second issue, Your Lordships. Much obliged, Your Lordships.
If it pleases Your Lordship, the Council seeks permission to continue from where my co-counsel left. Much obliged, Your Lordship. Your Lordship, the petitioner, when applying bail to the Honorable Court, has willingly agreed to abide by any condition imposed by this Honorable Court. This was not under duress. It was a clear, conscious acceptance. Now, after enjoying the liberty granted on those those terms, the petitioner is now using privacy as a shield only when it suits their narrative.
Can there be a waiver of fundamental rights under our constitution?
Your Lordship?
Can there be a waiver of fundamental rights under our constitution?
No, Your Lordship.
It's not permissible, right?
Yes, Your Lordship.
So he's not waiving, he can raise up this issue at any point in time.
No, Your Lordship, when the accused is applying for bail, he is giving consent to the Honorable Court that he will abide by any condition which is imposed by this Honorable Court. So considering the fact that he has accepted that live location tracking can be imposed, and after enjoying all his rights after getting out on bail, now he is filing a special leave petition stating that it is violating his right to privacy. If he would have thought that it would have really violated his right to privacy, he would have stated that it is violating his right to privacy that moment itself. He could have said that this bail cannot be granted, and because it is going to violate my right to privacy, Your Lordship.
There can be no estoppel against the statute and the constitution.
Your Lordship?
There cannot be any estoppel. You are on the principle of estoppel now. Having agreed to the bail condition, he cannot challenge it later. That is the principle of estoppel, right? So
Yes, Your
that
Lordship.
apply to a statute and the constitutional law.
Your Lordship, the Council is trying to establish that when the Honorable Court has stated that this kind of a restriction is going to be imposed, the petitioner would have stated that it is going to violate his right to privacy.
Does the proposition say that that is the normal condition that is imposed for every other prisoner who is let out on bail under the NDPS?
Your Lordship?
This is a normal condition that is imposed for him to have the knowledge that this is going to be the condition imposed, and thereafter agreeing to whatever be the condition that is imposed will be accepted.
Your Lordship, the Honorable Court has asked the petitioner to share his live location.
It's not there in the proposition. That's the one. That is the order.
Yes,
See,
Your
the
Lordship.
petition says the petitioner shall abide by any condition imposed upon by the court on being released. That would be the normal phraseology that is used.
Yes, Your
Now the
Lordship.
court grants bail, imposes condition.
Yes, Your Lordship.
So can there be a deemed acceptance of whatever that has been imposed? Tomorrow the court says jump 150 times every minute.
No, Your Lordship.
But then,
Your Lordship, this does not violate his right to privacy, Your Lordship. Considering, Your Lordship, he is not restricted his right to movement. this particular live location tracking, it doesn't, is not going to grant access to any messages, emails or phone calls. And it does not reveal content of the accused communication as well. So that is why he's free to go anywhere he wanted to and he can do whatever he wants to. Considering the fact he's going to, if he's not going to curtail to this bail condition, his bail is automatically going to get cancelled. So considering that, Your Lordship, this is not a violation of his right to privacy. If Your Lordship is satisfied, the council seeks permission to further move the arguments. Your Lordship, as per paragraph 5 of the MOOT proposition, the petitioner is a foreign national. The state has a duty to protect its people, especially when 60% of those affected are youth. Your Lordship, keeping a close watch on a foreign national is a reasonable step to prevent any possible threat. Your Lordship, according to the maxim Salus Populi Suprema Lex, it states that the safety of the people is the supreme law of the land. And according to another doctrine, Salus Republicae Suprema Lex, the safety of the state is considered to be as important. Your Lordship, under Section 4 of the NDPS Act, which clearly states that central government may take measures for preventing and combating abuse. Hence, filing a case against the government stating that the measures taken by the government in good faith is also considered to be as a violation of Section 69 of the NDPS Act, which states that no suit, prosecution or legal proceeding can be laid against the central government if the measures are being taken in good faith. Your Lordship, is the petition...
That is to curb the drug abuse.
Yes, Your Lordship, but the Learned Counsel has mentioned the arrest itself is arbitrary. So for that argument, I have mentioned section...
Which one is arbitrary?
The arrest itself is considered to be as arbitrary.
That is their state.
Yes, Your Lordship, and that is why...
always claim that it is arbitrary, without any material, he's been arrested.
Yes, Your Lordship.
Now that you have termed him the Lord of Drugs.
Yes, Your Lordship.
But why was he first let out on bail?
Your Lordship, he has satisfied the twin conditions mentioned under...
To impress upon the court that he is an hardened drug criminal.
But Your Lordship, the High Court has additional... the High Court can impose additional restrictions.
Did you file for cancellation of bail before the Supreme Court?
Your Lordship?
Did you file a cancellation of bail before the Supreme Court? You had an option that the High Court was erroneously let him out on bail.
No, Your Lordship.
No, fine. No, the state has a responsibility.
Yes, Your Lordship.
When you call a person a hardened drug lord, you should make sure that he's still in the prison. That is why the condition.
Yes, Your Lordship. Your Lordship, where the petitioner has cited the case of Frank Wittis. In that case, the Frank Wittis was arrested under Section 8, 22, 23 and 29 of the NDPS Act. Your Lordship, every case is different. So considering the gravity of the offence committed, the Frank Wittis case is completely different from the Walter White case mentioned here. Your Lordship, unlike the case in hand, Frank Wittis was not involved in narco-terrorism or funding terrorist organization in specific. And it's very clear that the case in hand is completely different. And Your Lordship, in Gurpaksh Singh Sibia versus State of Punjab, no such rules can be laid down for a reason that in a given case turns out to be conclusive, may have no ordinary significance in other cases. Your Lordship...
Sibia case is more benevolent towards the accused. Why is the state relying on that? Taking a line out of it?
No, Your Lordship, considering the fact that the petitioner has mentioned about the Frank Wittis case, comparing that case to the Walter White case, the council is stating that no such rules can be laid just because the significant case states another. And also considering that is a division bench, Your Lordship, sir.
5 of us here. Only Bhattaswamy is on top of us.
Much obliged, Your Lordship. Your Lordship, considering the argument which was placed by the petitioner, the case in hand is considered to be completely different. And Your Lordship, in the case of Emperor versus H.L. Hutchinson, no hard and fast rules can be laid down in discretionary matters like the grant or refusal of bail. Your Lordship, under section, when the court grants bail under section 437 and 439 of the CRPC, it is not an act of generosity and it is a calculated decision, Your Lordship, balancing individual liberty with the interest of justice. But Your Lordship, should a man accused of running a sprawling narco-terror syndicate be treated the same as an ordinary offender? Your Lordship, in cases involving heinous offences like narco-terrorism, the judiciary has the discretion and the duty to impose stringent safeguards to prevent flight risk and ensure effective monitoring. Moreover, under Section 482 of the CRPC, the High Court and Sessions Court have the inherent authority to impose or modify the bail conditions when the situation demands stronger restrictions. And if there was ever a situation that warranted the strictest of conditions, and obviously then this is going to be the case, Your Lordships. And Your Lordships,
Sharing location, how does it even ensures that the person is there in that location? You call that a strict monitoring, surveillance for a person let out on bail. I have my mobile phone here. I keep it, go, take a drive and come back after half an hour. Does it mean to show that I'm still here, sitting here, doing nothing?
Your Lordship, that can be done like switching phones and all of that. But Your Lordship, there is a provision for cancellation of bail, and if there is any information regarding the same has been brought
Why
out.
don't you get information if you don't get information?
Your Lordship, under Section 28, Clause 5 of the MPCA Act, the same Act, the release of high risk or an under trial on bail shall be informed to the Superintendent of the Police to keep watch on activities of such prisoners. So, anyways, under the MPCA Act,
That's worse. You're monitoring a person, physically surveilling a person, shadowing a person. Is worse than asking a person to.
Your Lordship, considering the Google location has already been implemented, this is an additional measure.
Google location can be tampered. Can be easily tampered with.
But Your Lordships, considering Google location, this Google software has been used by almost every single part of our country for a lot of different agencies, for a lot of different disaster responses. And considering the same, no system is considered to be flawless, Your Lordship. But at the same time, if there is any evidence that this particular petitioner has done any other act which is not conforming with the law, then obviously his bail is going to get cancelled, and it is obviously a negative impact for the petitioner, because the proof is on the petitioner to prove that he is considered to be, he will follow all the rules of the bail conditions. So considering that fact, obviously
The petitioner's contentions would be that the prejudice is caused because of the intrusion of privacy. So you have to counter that. You are the state and you're before a 5 judges bench.
Your Lordship, the Learned Council of Petitioner has been asking for far less intrusive measures. Your Lordship, by applying the doctrine of least restrictive measures, this particular Google Live location is not going to message, it is not going to take any messages, or is not going to track any phone calls. But Your Lordship, considering another alternatives which has been used in New Zealand and a lot of other international countries, they have been using this system called ankle monitoring, and the same has been used in India as well in the case of Ghulam Mohammed Butt, where it was the first case.
The IMF chief was tagged with an.
Much obliged, Your Lordship. So considering that case, comparing that case, the Ghulam Mohammed Butt, he was also involved in funding the terrorism organizations. And the same Walter White has also been involved in funding terrorism organizations, Your Lordship. But considering both the case in hand, Your Lordship, the imposition of live location tracking is compared to be far less intrusive measure than ankle monitoring. If the petitioner is ready to wear ankle monitoring, which is going to be a more intrusive measure, then the state has no denial of that, Your Lordship.
Do we have those number of anklets?
Your Lordship, the condition has been imposed. The petitioner accepted for that condition, and now he's filing it.
We don't have that. India is a poor country. We don't have a number of anklets to affix it on every other ankle of the accused.
Yes, Your Lordship, considering it is very costly, it's not available in India as well. But the fact that I am trying to present here is that the measures imposed on the petitioner is far less intrusive. It is not beyond the scope. And there is no way in restriction of right to privacy, considering we are not stating him not to move anywhere. He is free to go anywhere. He can move here, he can move there, he can move anywhere, Your Lordship. But considering the fact, you just share your live location. That is all we are asking, Your Lordship. Your Lordship is satisfied, the petitioner.
Here comes the question of what will be the psychological effect on that person who is being continuously monitored, continuously under surveillance. That need to be looked into, because he is an under trial prisoner. He is not even the trial has not yet started. So, being a welfare state, it is the duty of the state to see both the citizen as well as the foreigners will be, justice will be equally distributed. How will you look into the psychological aspect of dealing with the prisoners or under prisoners?
Much obliged, Your Lordship. Your Lordship, there is a concept called panopticon concept, which was first introduced by Jeremy Bentham, and later is expanded by Michael Foucault, which states that the power of surveillance does not lie in direct oppression, but in knowledge that one may be watched, thereby discouraging wrongdoing. So when the main aim is that, Your Lordship, prevention of any other crimes. Considering the petitioner he is moving in an area, or he is walking through an area, and he is always reminded that particular Google Live location is constantly shared to the other police authorities. So subconsciously, he is getting into a fact that if he does any of the wrongdoing, his bail is going to get cancelled. And that was the principle we are trying to implicate. The counsel for the respondent is trying to justify with that principle, stating that it is a reformatory measure also.
But subconsciously, there can also be a fear that anytime there is a drug trafficking case in that locality where I somehow happen to go, now these guys are going to pin it on me. That is also a subconscious fear, right? So I think, when we talk about fears, we have to be a little more balanced in our assessment, right?
Your Lordship, answering to that question, the state does not show any discrimination between a foreign national and an Indiana national. Your Lordship, in the case of Lambert Kroger versus Enforcement Directorate, it clearly states that though the possibility of fleeing from trial may be more in the case of a foreign national, it cannot be said that the accused cannot be granted bail merely because he is a foreign national. And Your Lordship, there is no law which authorizes or permits discrimination between a foreign national and an Indian national in the matter of granting bail and imposing conditions, Your Lordship. So the state is very clear on not to discriminate between Indiana national or foreign national. Considering he is out on bail and he is a threat to national security, as mentioned clearly in Moot proposition number 6. So, Your Lordship, in Moot paragraph number 2, 60% of the Indiana's population is below the age of 35, and that is youth. So obviously, Your Lordship, individuals' liberty will always outweigh in considering the national security, because the state is obligated to protect the citizens of Indiana from the other threats as well, Your Lordship.
But I counsel again, the very emphasis in my sister judge's question was on the word under trial. What does that mean? It means something, right? A person is not convicted yet. Even under the NDPS Act, whatever be the legislation, we still have a responsibility, right? So when someone is under trial, do you want to submit that individual to this constant sense of exactly the panopticon that you mentioned, in the sense that, oh, if there is a crime tomorrow in that locality, I am going to be the one, accused of it.
Your Lordship, answering to the question, the Google location has already been shared. And for example, let us take there is a crime happening in that area. So there, with that position, the police authorities are obviously going to check where this particular person was available at that point. So we can easily identify whether the person was there or not. And obviously there is no chance of pinning it on this individual, because it is clear that his Google Live locations are being shared all the time. So he can easily justify it by stating that I was not there at that time, Your Lordship.
Okay, proceed.
Much obliged, Your Lordship. Your Lordship, given these facts, relying on traditional bail measures to such a drug lord would be the judicial equivalent of handing a wolf the keys to the hen house. Expecting him to adhere to standard conditions is not just impractical, it is a recipe for disaster. And the Indiana's judiciary cannot function and cannot release a person on bail just because of a trust. Your Lordship, we are not ready to trust our car keys to a random stranger, because the trust always plays a major role. Your Lordship, considering that, releasing this petitioner without any provisions of restrictions is obviously considered to be a threat to the Indiana's national security, Your Lordship.
But was bail jurisprudence built on the idea of trust, or was it built on the idea of liberty?
It is based on the idea of liberty, Your Lordship. Your Lordship, we are not we are not saying that we're not going to grant, the court has granted bail and he has the right to bail under section 50 of CRPC. And we are not restricting his grant of bail. But your lordship, the proof is on the petitioner to prove that he will not be a threat to the security, and the condition is not going to be imposed throughout. It is only till the trial is going to take place. And after the trial, this whole location tracking or live tracking is going to go off. So considering that condition, this whole live location tracking is considered as a valid provision, your lordship, considering the threat which he is supposed to be posed.
Even without the person submitting himself for this kind of tracking, the police still have the measures to clandestinely track down mobile phones. Are you aware of it?
Your
Why do you want to make things so explicit for him to file a petition and invite trouble for himself?
Much obliged, your lordship. Your lordship, under Google services, the location always gets tracked. But the Google services will send send wherever you've been to only to you, your lordship, only the person who is using that email ID. So considering the police authorities have all the access. Yes, your lordship.
This is out of practical experience. You don't have to share your location for the police to find where you are. Every other case, once the anticipatory bail is filed before the court, the police starts monitoring the person. They know where he is. It's a normal thing. So state can use these kind of measures. No, it's ultimately in the interest of the nation. Tomorrow, if he's going to get apprehended, if he's going to flout the bail conditions, and if he's going to get arrested, he cannot take a plea that, no, they clandestinely tracked me. Ultimately, they can use measures to track a person. Why did you want to impress upon that?
Your lordship, specifically mentioning about Google in the matter of case in hand.
Is it fair play?
Your lordship?
Is it fair play?
No, your lordship, I will answer to the question, your lordship. Your lordship, the Google services is going to track your location and is going to send it to you personally. But if the police officials are going to, if they want any information from this Google specifically, they have to ask permission to the Google. And the Google is obviously going to ask permission to the concerned person as well.
If he is an accused, the Google will not ask the permission of the person who is accused of a crime. If the police requests for some information from an agency, they are bound to produce those because it relates to an offender, not some random individual.
Your lordship,
So that need not be. That's not actually correct.
okay, much obliged, your lordship. Your lordship, considering the matter in hand, the petitioner is as the honorable justice has mentioned, the petitioner is obviously going to be monitored. But considering he's a foreign national, the state of Indiana, it requires a direct consent from the individual. Your lordship, he has consented that he will abide by the bail condition.
There was no consent. That is why they're challenging that.
Yes,
It was an omnibus statement that was a plea that was made in the bail petition saying we'll abide by any condition. So it is not a consented one. You cannot force consent on a person when the consent is not explicit.
Much obliged, your lordship.
That is the problem. You have given such a leeway for them to play around with.
Your lordship, he has been tried under section 37 of the NDPS Act. I mean, he's been... Apologies, your lordship. Much obliged, your lordship.
10 more minutes. 10 more minutes.
Your lordship. Much obliged, your lordship.
Did I interrupt the flow? Take your breath.
No, your lordship. I just forgot where I was in the space. Your lordship.
Take your time. The moment you start, 10 minutes from there.
Your lordship, with reference to MOOT paragraph number 6, doctrine of constructive liability is applicable as it holds individual accountable even if they facilitate, conspire, and even if they don't personally commit the act. Your lordship, this case is not merely about drug trafficking. It is about an orchestrated assault on national security. Under Section 121 of the IPC, waging war against the state, his actions invite the harshest penalties, which is death or life imprisonment. Your Lordship, considering he has satisfied the twin conditions as mentioned by the learned counsel, that the public prosecutor has to be given an opportunity and the court is presuming that he is not guilty of the particular issues mentioned. But your Lordship, even though he has been released on bail, the CRPC clearly mentions that additional conditions can be imposed. And your Lordship, my contention is that it is a clear statement that it is not a violation of privacy because the accused is not restricted from moving anywhere. And your Lordship, when a crime threatens public order, incites violence or endangers national sovereignty, the charge of sedition under Section 124A of the IPC is not far-fetched and is inevitable. Your Lordship, in the Supreme Court in the case of Kedarnath Singh versus State of Bihar has upheld that acts aiding or abetting terrorism justify stringent legal conditions. Your Lordship, in a lot of foreign countries, this particular electronic monitoring has already been imposed and they also have legislative frameworks for the same. This measure, the Google Live tracking, is considered to be as a far less intrusive measure and it satisfies all the legality, necessity and the proportionality test as mentioned by the learned counsel. If your Lordship is satisfied with the arguments, the counsel for the respondent likes to move to the prayer.
Now they will have to again reply.
Yeah, you want to add something more, you can add.
Oh, I'll add in sub-rebuttals, Your Lordship. I will add that in sub-rebuttals, Your Lordship. Much obliged, Your Lordship. Prayer.
Agreed by the order, they have not filed any modification.
Your Lordship?
Agreed by the order, said order, they have not filed any modification before the Honorable High Court.
No, they have filed for modification, Your Lordship, stating that it is a violation of right to privacy. And it is in the discretion of the Honorable Judge Bench to declare whether it is a right to declare whether it's a violation of right to privacy or not, Your Lordship. Much obliged, Your Lordship. Wherefore, in the lights of issues raised, arguments advanced, and authorities cited, it is humbly prayed that this Honorable Court may be pleased to adjudge and declare that the Honorable Supreme Court may be pleased to hold that the installation of AI-powered CCTV cameras, including in the cells of inmates within the prison complex, doesn't violate the right to privacy as guaranteed under Article 21 of the Constitution of Indiana. That the Honorable Supreme Court may be pleased to declare that the imposition of the condition requiring Walter White to share his live location with the SHO of the local police station at all times while being on bail does not violate his right to privacy as protected under Article 21 of the Constitution of Indiana, and or pass any other order or orders as this Honorable Court deems fit and proper in the circumstances of the given case and in the light of justice, fairness, equity, and good conscience. The Council pleads this Honorable Court to bind Sacramentum habent instatus comites veritatem, justitium et judicium, veritas habenda est in jurato, justitia et judicium in judice. And for this act of justice, the respondent shall be duty bound and forever pray. Much obliged, Your Lordship.
Your Lordship, with the permission of the court, the council would like to state two things first. It is no new submission. The council was not able to answer Madam Lordship's question priorly. In the heat of the moment, the council could not recall. The writ is a prerogative writ that can be issued by the Supreme Court as a part of suo motu cognizance, and guidelines were given in the Sunil Batra case, and it has been submitted as a part of compendium page number 74 to 79. The council seeks.
I was asking the name of the writ, the
Name of that jurisdiction.
Okay, we are seeking for a writ of mandamus. However, when yes, Your
My
Lordship.
question was the name of the jurisdiction,
This is a
like an original state jurisdiction.
This is a writ jurisdiction, Your Lordship. Yes, for the just to clarify, it is a writ jurisdiction for under its first issue. However, a special appeal has been filed for the second issue. Now it is clubbed under Article 139A. So it is a clubbed petition that was being heard. Yes.
My question was entertaining a letter, as a writ.
Yes.
It is epistolary jurisdiction.
Understood, Your Lordship. Okay. Apologies for that. Yes, the council seeks permission to proceed with the rebuttals.
Are both of you doing rebuttal or only one?
The petitioners will do rebuttals and the respondents will go for sir-rebuttal.
No, is it only one speaker?
One speaker, Your Lordship. The petitioner will keep it very short and crisp. So there are majorly 5-6 points that the petitioner wants to address. The respondents time and again have stated, with respect to issue 1 firstly, time and again have stated that we have agreed that there is a legitimate state action and also that there is a law binding. Yes, we agree, but the means that are used to achieve the end is not. And however, apart from MPCA Act that the respondents are citing, in that also there is no provision for AI-powered CCTV cameras. So the council questions the respondents as to from where other than MPCA Act they got the guidelines, and why was there no notification in the official gazette when such a big issue has been raised. Secondly, the petitioners, the respondents stated that AI-powered CCTV cameras will give prior alerts to ensure that the mishap won't happen. However, to do this, a training data has to be fed into AI. Now, where did they get the training data from? What training data did they use? And what is the authority with which you use this training data? Because in India, nowhere else, yes. Apologies, Your Lordship. Because apart from international countries, in Indiana there is no training data that is available for such. So with what authority such training data was used and what training data was used to feed to the AI? Then also, all of us in the courtroom are very aware of the Satyendra Jain leak case. Even he was in a high security prison. His cell had a CCTV camera and the camera footage was leaked. Now when such footage is being leaked, how will the prisoners also trust that what the state is doing will be protective of their rights? How will their privacy still be protected in such a case? In US also one case, similar case happened, and the inmates in the room were discussing, don't laugh so hard, we are caught on camera. So that is the kind of impression that is on the inmates, Your Lordship. And petitioner, the respondent stated that the petitioner agreed that right to privacy is absolute. In the starting, my first sentence was, we agree right to privacy is not absolute. But again, the means you are using to achieve the end is not justified. And last 3 points, Your Lordship. The court, just 2 points at least, much obliged, Your Lordship. The court, they stated that contraband may be circulated even in high prison cells. That's why we need AI camera. Is the state questioning its power to stop all this, or what is the state doing when all this is happening? Is AI the only solution to it? And we also did not agree for any bail condition that will be imposed, Your Lordship. My co-counsel clearly stated that bail conditions with less intrusive means will be agreed upon, and as per established principles of CRPC under section 467, no extra bail conditions can be imposed, and you cannot broaden the already existing bail conditions. How did they state that you can exceed when the principles are already clearly established? These are the rebuttals. It was an honor arguing before this bench.
As per the Act, the word technology is used.
Yes, Your
So
Lordship.
it includes the IA also.
In MPC.
Yes.
Yes, Your Lordship, but there is no notification or anything that is released to us, Your Lordship, because when such a big change is being done, the prisoners and the country should be made aware that this will be done. Even though it is technology, even in IT rules and IT Act, Your Lordship, every time there is a change, there is a notification in the official gazette or notification to the people that, okay, you will be governed under these rules right now, which draw their validity from these provisions of the Act. But this was not in the present case. Again, we are not against AI-powered CCTV cameras, but where are you getting the training data from, and what is the authority you have to do it?
Are you conceding that installation of AI-powered CCTV inside the cell is okay for you?
No, Your Lordship. It is not okay, but unless we get to know where you're getting the training data from, and unless we get a proper notification and information that this will be the norm from now.
No, but what does that notification got to do with your thing? Should it be notified to every other accused that, these are the things that we're going to do?
No, Your Lordship.
Then?
Usually, when such things happen, it is notified in the official gazette that such a big change is being brought.
So if it is notified, you'll stop peddling drugs?
No, Your Lordship. Even if it is AI-powered CCTV camera, not in the cells. That is what the council is trying to say. In the cells, no camera, not AI-powered, not CCTV camera. You can use AI-powered outside. in the common areas, but if you prove the validity of the training data you're deriving from, because India does not have any training data as such. You have to borrow from foreign countries only.
That seems to be the drawback.
Yes, Your Lordship.
Agreed by the bail order, have you preferred any modification in the same High Court?
Yes, Your Lordship.
No, you have not made
No, we filed for a special leave petition. The moot proposition is silent on that aspect.
You
Even
straight away approached the Supreme Court, you have not filed any modification in the local.
No, Your Lordship. As per the instructions we received from our client, this was what we thought would suit the best because it is a matter of grave interest. So we thought a constitutional bench would be the right to judge in this matter. They continuously also stated that we exercise the bail, and after exercising the bail, we are questioning upon the bail. That is nothing like that in the moot proposition, Your Lordship. The moot proposition clearly states the next line after the bail was granted, condition was granted, the next line of the moot proposition says that special leave appeal was filed already. So we did not exercise the right as such, Your Lordship. As soon as we were granted the condition, we filed a special leave appeal. We did not exercise it and then start complaining upon it.
Yes.
Much obliged, Your Lordship. This was an honor arguing before this bench.
Lordship, the council seeks permission for self-rebuttals. Much obliged, Your Lordship. Your Lordship, the learned petitioner has mentioned that there has been no notification in the official gazette. Your Lordship, the Joint Secretary of India has clearly signed and released an order to the Director General of Police on April 28, 2015 in the official gazette of India stating that every inmate cell will have CCTV. Your Lordship, considering the development from 2021 to 2025, AI serves as an additional tool to serve this measure. And considering the developments, obviously, Your Lordship, the Joint Secretary has signed an order and he has clearly released the order in the official gazette, Indiana's official gazette. Your Lordship, considering the second issue, the Learned Counsel has mentioned under Section 43D, Clause 5 of the UPA Act, he had mentioned that bail has been granted because he has satisfied the condition laid on in Clause 5. But Your Lordship, the clause says that in the UPA Act, notwithstanding anything in the code, no person accused of an offence punishable under Chapter 4 and Chapter 6 of this Act, if in custody, be released on bail or on his own bond unless the public prosecutor has been given an opportunity. Your Lordship additionally provided that such accused person shall not be released on bail or his own bond of the court on perusal of the case diary or the report, which is the charge sheet in the present case, made under Section 137 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Your Lordship, under the UPA Act, there is no provision stating he has not satisfied the provision in the UPA Act at all, Your Lordship, and mentioning that act in this particular case is considered to be completely irrelevant. Your Lordship, the Learned Counsel has mentioned about the Frank Witness case, which is the two-judge bench. Your Lordship, there has been another case stating that Shoma Sen versus State of Gujarat. Your Lordship, in that case, they have stated that live location tracking is a must because the particular case involved around funding of the terrorist organizations. So, considering the matter in hand, Your Lordship, if a two-judge bench disagrees with another two-judge bench, like Shoma Sen State of Gujarat, the judicial propriety requires a coordinate bench to refer the matter to a larger bench, and that is why the whole case has been brought to the larger bench, Your Lordship. Your Lordship, the Learned Counsel has already mentioned about the meeting of the husband and wife in the presence of a police officer. Your Lordship, how does it even violate? 24/7 location, the police official is just watching him from Google Maps. It doesn't know who is he with, who is he talking to, or nothing else. But how does it even violate the particular case with the matter in hand is just a matter of question, Your Lordship. Your Lordship, and also the Learned Counsel has mentioned about the arrest, which is considered to be as arbitrary. Your Lordship, under presumption of culpable mental state in section number 35 of the NDPS Act, if the Lordship gives permission, I can bring the NDPS Act. Much obliged, Your Lordship. Much obliged, Your Lordship. Your Lordship, in the NDPS Act of section 35, it states presumption of culpable mental state. In any prosecution for an offense under this act, which requires a culpable mental state of the accused, the court shall presume the existence of such mental state, but it shall be a defense for the accused. Your Lordship, may I just grant 30 seconds. For the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in the prosecution. Your Lordship, with reference to the matter in hand, this person has been present in a particular area where the NCS has conducted a mass raid. So considering that scenario, the presumption of culpable mental state is present.
Those are submissions that are to be taken at the time of hearing of the bail plea. That all your submissions at the time of hearing of the bail plea has been disregarded and the bail has been granted, saying that twin conditions have been satisfied, that he is not committed the offence and he is not likely to commit the offence. That is what the stand taken by the court while granting bail. Now the issue is very short and simple. They say that installation of CCTV camera inside the cell is violative. It's too much of probing. And asking me to share my live location, it's intrusion of privacy. These are the two things that you have to defend. So we are not questioning the veracity of the offence and the heinous of the nature of the offence committed at all. That has been already decided by the court.
Much obliged, Your
That's
Lordship,
not
but
been
the Colonel Council has mentioned specifically in his argument stating that an arrest is arbitrary. For that statement, I've been mentioning this section 35 stating that the arrest can be done in the presumption of culpable mental state. Your Lordship, is satisfied with Sir rebuttals? The Council seeks permission to. Much obliged, Your Lordship.
It was a pleasure, but had I been the defense lawyer, I wouldn't have moved before the Supreme Court. Had I been the defense lawyer, I wouldn't have moved this petition. That's all that. What's next? Scoring.
Okay, ma'am.
Very precious.
ஐயோ தெரியாம green pen யூஸ் பண்ணிட்டேன் நான். Green pen.
முடிச்சிட்டேன்.
I brought my green pen. So anyway, I'll continue with green.
போடுங்க.
அதான் நான் திருப்பி நான் கேட்டுக்கிறேன்.
இது கரெக்டாக இருக்கா செக் பண்ணிக்கோங்க. $69, 65. Once again, add. It should be equal, no? Okay.
ஃபோட்டோ நம்பர் எல்லாம் போடணும். ஃபோட்டோ நம்பர் 1 போட்டேன்.
கோட் ஃபர்ஸ்ட் கோட். சீட்.
Once again, we'll check it out.
Use a calculator.
ஃபர்ஸ்ட் தங்கச்சி டன்.
You are having one, no?
Just want to make sure that everything is correct. அவன் ஞாபகம் இருக்காது. ரோனர் 7 First year. Law.
Just check the calculation.
First year.
Right.
What? No, no, I don't. What do you want? Check பண்ணிக்கோ. Petitioner is 7:30.
You change it, man. I give the full liberty, man. Which year, man? You are? கம்மியாண்ணா இப்போது இதுபடி எல்லாம் வச்சுட்டு ஸோ இல்லை அதுக்கப்புறம் அந்த தான் சரி சூப்பர் இல்லை இல்லைங்களா
He got the leads. Leads. So I don't know how you're trying.
You are from which place, man? Which place you are from? Yes, change it, man. Change it, man.
No, no. Actually, when I go
Sitting.
Sorry, 9 minutes. Both 9,
going with the prosecution, they have a very
9 and 9, ma. 9, yes. Almost finished, ma.
because you use the takeout. Now, second,
Yeah, I mentioned, no? Stuck out, petitioner. Yeah, I mentioned, ma. See, I stuck out this one, no? So,
ಕೋಟೋಲೆ ಖಾಲಿ ಇಡ್ತೆ
okay. She knows, no?
ಕೋಟೋಲೆ ಖಾಲಿ ಇಡ್ತೆ
Check. 2 minutes. 2 minutes என்ன நான் பேசுறது கேக்குதா? நான் பேசுறது தெளிவா இருக்கா? ஓகே. ஆஃப் பண்ணிடுவா.
Hello.
Good evening, esteemed dignitaries, revered faculty members, spirited participants, and dear guests. As the sun sets on 2 days of an intense legal battles, we gathered here to celebrate the culmination of 10th national level Moot Court competition at SRM ISD. Indeed, the past decades, this competition has been a crucible for budding legal minds, and today we honor not just the winners, but the spirit of learning, perseverance, and excellence that every participant brought to this arena. To begin this evening proceeding, let's invite Professor Dr. Sri Sudha, Dean School of Law, to deliver the welcome address.
Good evening, Honorable Lordship, Justice N. Mala Madam, esteemed Pro Vice Chancellor, Professor A. Vinay Kumar, and distinguished professors, Professor Ananta Padmanabhan, and my beloved friend, Professor Asha Sundaram from Savita School of Law, and two learned senior advocates to this august gathering. And I welcome you to this valedictory session. And after this, I welcome dear participants, students, faculty members, and staff members of School of Law. Really, it is an important day and significant day in the law school's journey. This is our 10th annual exercises. First of all, let me thank the administration for providing an opportunity to organize this kind of prestigious events at School of Law. The reason behind organization of this kind of moot court programs is to instill critical thinking in the young minds. Law being a dynamic subject, sometimes it may or may not be in a position to address the intricate questions, challenges which are persistent in the society. That is the reason why this moot court will provide a wonderful opportunity for the purpose of harnessing their skills towards this critical thinking. First of all, I congratulate organizing committee as well as mentors, coaches who have relentlessly worked hard for the purpose of organizing this event, and moreover, our esteemed judges. They were so patient and they have given an opportunity to each and every participant to hear their arguments, and moreover, the rebuttals will have provided an opportunity to all the presenters to share their perspectives regarding many dimensions associated with this privacy as well as technology law related aspects. And the feedback which is given from the side of all the judges is very essential for the purpose of learning and relearning certain intricate doctrines associated with this law. So finally, I welcome each one of you for this valedictory session. And it is a remarkable event in the history of School of Law. And I congratulate each and every participant because each one of us is, and ultimately we have proved that truth will trumpet always. Thank you so much.
Thank you, ma'am, for your gracious words and for fostering this platform where legal minds spread their wings. As a token of love and gratitude, I would like to invite our Pro Vice Chancellor to felicitate our Chief Guest, Honorable Justice N. Mala. As a token of love and gratitude, I would like to invite our Dean Ma'am, Dr. Sri Sudha, to felicitate our Chief Guest, Professor Dr. Anand Padmanabhan. As a token of love and gratitude, now I would like to invite Professor Dr. Ishita to felicitate our guest, Professor Dr. Asha Sundaram. As a token of love and gratitude, I'd like to invite our Dean Ma'am to felicitate our guest, Advocate J. Raja Samuel and Advocate Johnson Satyan. Ladies and gentlemen, tonight's pinnacle moment is here. We are deeply honored to have among us Honorable Justice Yan Mala, Judge, High Court of Madras, to deliver the valedictory address. Honorable Justice have been graduated law from Madras Law College and enrolled in Bar Council of Tamil Nadu and Puducherry in August 1989. She started her practice from a senior counsel R. Sundaravaradhan. She started her practice in civil appellate side and gained vast experience. She held many positions including but not limited to government pleader, panel advocate for United India Insurance Company and New India Assurance Company, panel counsel for AFT, Pondicherry Engineering College and Pondicherry University, panel counsel for AFT, Pondicherry Engineering College, and appointed as a panel counsel for High Court, both Madras and Madurai bench by ICMR, appointed as a panel advocate for High Court Loka Dalit, presided Mega Loka Dalits along with Justice K.K. Sasidharan and Justice M. Satyanarayanan. Ma'am, your presence here bridges the gap between an academia and judiciary, showing us the real world impact of the skills honored here. The stage is yours.
Yes, good evening to one and all. Congratulations to the winners. By winners, I don't mean only the persons who are now going to the team which is going to lift the trophy, but I also mean all the participants. I congratulate you all. I am congratulating the participants also, because it is their hard work which has also helped the winners come out successful, because they have given them such tough competition. I also consider all the participants here, both winners, runners-up, and mere participants, as winners because of the rich knowledge and experience you have gained out of this competition. We all know that this is a cricket season. Cricket is a toast of the season, and so let me draw some parallels with cricket and our profession, that is law. A sparkling cover drive of Virat Kohli is powered by muscle memory. As students aspiring to become advocates and entering the profession, you should practice to develop mental power and memory to showcase your talent before the court and the world. Cricketers practice long hours at the nets to hone their skills of choosing the right ball to banish to the boundary. Moot courts are like cricketing nets. They create a platform for initiating you into the highly competitive profession of an advocate. Just like cricketers choose the right ball to hit a sixer, the advocates should practice to pick the right points in the case to win the cases. For those long hours of reading and practice is necessary. Competitions like this prepare you for the bigger stage. Judicial time is precious. Because of the heavy pendency, there is no longer time to listen to lengthy arguments, and so you have to develop the skills of putting forth your case without wasting time. The preparation of pleadings and the case may take a lot of time, but when you present the case before the court, it should be precise and convincing so that the court's time is not wasted. This can be achieved only by practice and perseverance. The importance of practice and perseverance was beautifully described by Master Bruce Lee. The master says, I fear not the man who practices 10,000 kicks once, but I fear the man who practices one kick 10,000 times. Friends, before parting, I would like to share my apprehensions about becoming a litigation lawyer. Probably it was because of my height. I told myself that this is a profession where you need to be heard and not seen. So I took the plunge. The transition from being hard to hear, the transition from being heard to hearing has been a long journey. The journey has surely not been rosy, but spiced with unexpected challenges. To navigate the obstacles and reach the goal was the aim. Hence, I am here before you. Please remember that success or failure is in your mind and your hands. So move on like the waves which do not rest till they reach the shores. All the best to you. This is what I had actually prepared. But now I see a lot of young students aspiring to become judges and lawyers, first lawyers and then judges. So I would just want to find out from you people, how many of you are really interested in practicing law, practicing an advocate? I don't think this is a majority. What about the others? What about the others? And I haven't seen many girls' hands going up. Why? Why? May I know from any one of them? Can you just give this mic to them? I want to know from any one of the girls why they are not interested in taking up litigation. Yes. Can you tell me why you are not interested in litigation? You want to go for the services, judicial service. Okay, so more secure future, yes. What about the others? Any other person?
Oh, I'm more interested in the corporate sector. I'm doing CS as well, so.
So, why the corporate sector and not practice? May I know?
I might go into litigation, but in the corporate side as well.
Yes, anybody who would like to go on the litigation side and say why you are not going for the corporate, because she's given her explanation for going to corporate.
The main reason is if I go to corporate, it will be 9 to 5. But if I work as a litigation, it will be 9 to 9. And I can respect to what I'm working first.
Yeah. You mean that you will be your own boss? Yes. Yeah. See, when students come to me and they tell me that they want to go and join the corporate, I tell them that, see, as far as this profession is concerned, there are different kinds of persons who come here into the profession. Some of them come here to make money. Some people have ambitions, like me. And there may be some people who want to do service. Like she said, she wants to join the judicial service. So whatever you want to do, I think that you have to dedicate yourself to whatever you do. See, I can talk about myself, because when I joined the profession, I am a first generation lawyer. I was a first generation lawyer, had absolutely no guidance about the profession. And I'll just tell you an anecdote which Satyan knows. When I said, when I was elevated, in my speech I had told this. See, it's an anecdote which really happened. It's very surprising, but I don't know. I was so ignorant. So, when I joined the profession and I was to enroll, and I had joined under a senior who used to wear a coat similar to the judges. So, and for the enrollment, we are supposed to stitch our gowns. So I went to the tailor and I told him, I want a gown with a flap on the, near the arms and then a flap at the back and all that, which was a judge's gown. So the tailor immediately saw me and he said, Amma, inna, enrollment done, adukella romba nero irukku. So I became pink in my face and I said, what is this? Then probably subconsciously, I decided on that day that one day I'm going to adorn the coat. So that is what I want you to people. So when you start in the profession, whatever it may be, you may a senior counsel, you may want to become a judge, and you know to become a judge, it's a highly competitive profession. And out of so many lawyers, only 65 judges are there in the High Court. So it all depends on how much hard work you have put. I'm not saying that those who have not made it have not put hard work on it or anything like that. There's sort of luck also involved there and God's grace, basically. I believe in God and therefore instead of saying luck, I will say His grace. And I would only say that you learn by mistakes. Once you enter the profession, as junior advocates when you enter, I feel that you should be prepared to know the section work before you become a good lawyer. To become a good lawyer, you have to be a good clerk. You have to be a good clerk. You should know your way in the registry. You should know how to move the papers from the time you are filing the paper in the registry to bringing it in the list for hearing. You should know the various stages the paper passes. I find that nowadays, lawyers, young lawyers, don't prefer to go to the registry at all. They think it is below their dignity to go. They say that clerk irkara, avaru paathu paru, clerk irkar. That should not be the attitude, because once you go into the registry, there's a lot to learn in the registry also. The provisions of law, when you file an application for stay, then when you file an application for stay, you say it is section 10, read with section 151 CPC. You write it 20 times. It gets into your mind. If you read it for the purpose of your exams, you may not retain it. So when you go to the registry only, you will be able, and you have so many procedures that when you enter into the registry, you will be learning a lot of procedures, and procedures will help you to become a good lawyer. And as far as the preparation is concerned, I would say that you have to spend the maximum time in preparation. When I used to prepare for a case, I used to discuss the case with my senior, and even after I became a government pleader, when we used to file counters to the writ petitions, I used to sit with my senior government pleader and we used to read 226, 100, I would have read 226 100 times. Every time you read a provision, there'll be a different interpretation. That is the beauty of reading the provision, because once you are appearing for the petitioner, the other occasion you'll be appearing for the respondent. So any provision, it may be 226 Constitution, it may be any provision of law, a statutory provision, you have to read it 100 times, because every time you read it, your brain is such that it will try to mold it, it will try to interpret it in the form you want and which will help your case. So you have to develop the habit of reading. I'm sorry, I think I'm preaching more, so I think I should be stopping here. So I'll only I will only say that whatever you do, do with dedication, and like I say, I've always said, and that has been the, I would call it motto also. God delays but never denies. So be prepared. Yes, thank you.
Thank you, ma'am, for your reflection on different roles in advocacy and the power of dreaming, manifesting, and shaping careers will resonate with all of us. As we move on to the ending of this event, I would like to call Professor Dr. Ishita Chatterjee to give us a walkthrough from designing a moot court problem to successfully conducting our 10th National Annual Moot Court of SRM School of Law.
Thank you, Dr. Kirtana. The 10th annual Moot Court competition was definitely a significant event in the legal academic calendar, attracting 50 participating teams from various law schools all over the country. The competition spanned 3 days, featuring several esteemed judges which definitely includes Honorable Justice Mala and a panel of another 4 judges who had judged the finals, as well as a conglomerate of academicians and the experts, or we can call it as an industry experts from various places of Tamil Nadu and near about. So the moot court competition was designed to foster the art of appellate advocacy among law students. It provided a platform for participation to engage legal argumentation, enhancing their skills in research, writing, and oral presentations. The competition was structured into written brief submissions and oral arguments, with teams arguing on behalf of and both the petitioner and the respondent. The preliminary round started on 4th of April, that is preliminary 1 and 2. Each participant argued twice, once on brief and once off brief, with each argument lasting approximately 15 minutes. The appellate or the petitioner could reserve up to 3 minutes for rebuttal. The judging criteria was on legal knowledge, clarity of arguments, presentation skills, and ability to respond to the questions. The octa rounds happened on the same day, where the participants who advanced from the preliminary rounds competed to the knockout format, with each round lasting for about 15 to 20 minutes. The judging criteria was same, like legal knowledge, clarity of arguments, presentation skills, and ability to respond to the questions. Then on the same day, we have advanced with the quarter rounds, where the teams competed in direct knockout format, with each team presenting their arguments before the panel of judges. Semi-finals took place today, that is 5th of April 2025, and the format was again similar to the quarterfinals, with increased scrutiny on the participants' ability to articulate complex legal concepts concisely. The final round was presided over Honorable Justice Mala, along with Dr. Anand Padmanabhan, Dr. Asha Sundaram, Senior Advocate John Sen, and Senior Advocate Raja Samuel. Each team presented their arguments, followed by rebuttals and sur-rebuttals. The judging criteria was comprehensive legal analysis this time, persuasive argumentation, and courtroom presence. This time, for the 10th National Moot Court Competition, we have received 50 participating teams, which from different national law schools as well as from the premier law schools of the country. The proceedings for the proceedings, the participants submitted again written briefs prior to oral arguments, outlining their legal arguments as well as other positions. We have judged the best researcher, we have judged the best memorial, and finally today we are in the conclusive part of the 10th Annual Moot Court Competition 2025. All the best to all the participants. We'll soon announce the winner and the runner-up.
And now, the moment we all have been waiting for, the declaration of results. Let's welcome Ishita ma'am to unveil the champions of 10th Annual National Moot Court.
All the participants excited, right? Are you not excited? Okay, let's start with the best speaker. Any guesses from any participants? No? Okay. To announce the best speaker, I would request Advocate Samuel to felicitate the students with the prize. The best speaker team is, Ganesh J from Vivekananda Law College, team number 25. Thank you so much, sir. Next is Best Memorial. The Best Memorial Award for this, I would request Senior Advocate John, sir, to kindly felicitate the students with the prize. Yes, best memorial. Some guesses might be there this time. No? Okay. Team number 19, Alliance University. It goes to Astha Jha, Jaya Mahanti, and Mr. Ganesh. Congratulations to all three of you. Thank you, sir. Best researcher. For this, I would definitely request Dr. Asha and Dr. Anand to kindly felicitate our students with the prize. Best Researcher Award goes to Savita School of Law, team code number 27. The principal itself is receiving the prize. Congratulations. Finally, the runners-up. Can I see both the teams who have appeared for the finals? Can you please raise your hand or rise yourself? Definitely congratulations to both the teams, both the schools. Both of you, both the teams are definitely the winners, but one has to come up as winner and runner-up. For this, I would request Lordship, Pro Vice Chancellor Sir, and Dean Madam to kindly give over the prize. The runner-up team. The runner-up team, team code number 31, Tamil Nadu Dr. Ambedkar Law University. Yeah, I'll hold it. You want me to hold? No, it's fine. Congratulations to the runner-up team. And all the best. Thank you so much. Finally, the winner. Team number 7, Narsi Munji Institute of Management Studies, Bangalore. All two of you. Thank you, Lordship. Thank you, sir. Thank you, ma'am, for doing the honors. Give the vote of thanks now. Me? Me? Give, I'll call you.
No event of this scale succeeds without tireless effort. No event of this scale succeeds without tireless efforts behind the scene. To express our gratitude, I'd like to invite Dr. Ishita ma'am to formally propose the vote of thanks.
Justice Mala and distinguished guests who have come here to judge the final round of the Moot Court competition, Dean Dr. Sudha, Dr. Ishita, other colleagues, students, participants. I think it was a wonderful 3-day event. And then, I mean, the whole law college was fully geared for this. And then finally we have, the winner, Narsimhanji, Bangalore. I happened to be the director of Narsimhanji a few years back, I think it's a good thing that, you guys have done it. And, I think next time our students, I think, should take this thing. But anyway, a winner is a winner, and everybody who has participated vigorously for this, I think deserve a huge round of applause for everybody. I think. So I am not a legal guy. I used to teach finance. So, there was a course that I used to teach called Financial Derivatives. And in Financial Derivatives, there was one topic that I used to teach. It's called exotic derivatives. And exotic derivatives are derivatives which are, very mathematical in the sense that, these are mostly bilateral transactions, but there are some exotic derivatives which are listed on the stock market too. And when you look at the transaction, so I'll give you an example. A lot of, the textile mill owners, I mean, the people who were doing textile business and then who were actually exporting these shirts to various countries, they have entered into exotic derivative transactions with some of the best investment banks in India, like Citibank, Society Generale, and things like that. And it so happens that it is a foreign exchange derivative. And in the foreign exchange, it's called barrier options. So in the barrier options, what you do is, if at all the exchange rate goes and hits a certain barrier, you get to pay something. If you don't pay, only, it is going to expire without any this thing. So basically, all these transactions were looking so good on the paper for the people who were entering, because there was zero upfront cost. Okay, but the promise was too big in the sense that whenever the exchange rate is supposed to be, weakening and this, that, they will get huge benefit in the sense that if our rupee falls and dollar increases, then they will get more dollars, in the sense that, that's a much better transaction. So in other words, everything in the transaction was so beautiful that, they said, we don't have to pay anything, but we'll get so much benefit. So a lot of people, entered into these transactions. It so happens that, the options never moved. It has to touch the barrier. If they touch the barrier, then you will get the benefit. If neither of the barriers are touched, then you will never have the benefit. So what happened was, then the opposite person has to pay. So it so happened that, the exchange rate moved in a band and it never touched the barriers. So what happened was, all these garment owners, factory owners had to pay crores of rupees to these investment bankers. They went to the court. Okay. Big guys, ICICI Bank, all these guys went to and then it was supposed to be challenged, Then the judge asked, hey, did you go through this document, the legal document? The legal document is 5,000 pages, and much of it is actually mathematics. Okay, advanced, integral calculus. Okay, and then they didn't understand this, so they said, you know what, they gave us a scenario, we said we have understood the scenario and we signed it, but we didn't know that it is so complex. So then they've asked some mathematicians also. A PhD in mathematics will not understand the complexity of the derivative. And there is no way any legal law can be passed, because there is so much innovation in financial instruments that you can never pass a bill for bilateral transactions. So it is impossible to actually sort of control the markets, So point is, finally here, garment factory owners, because they didn't understand it, okay? But the basic this thing is, if you don't understand some transaction, but if you enter it, you have the responsibility, right? It's a huge dilemma. So increasingly what is going to happen is, we will get into situations like that. Now, there's something called surveillance capital. You see all your mobile phones, and whatever app that you're using, it is almost impossible to understand the privacy laws. Okay? Google has a privacy law. It's so complex that it runs into thousands of pages, and then Google has arrangement with other apps. The app itself has huge privacy law, and there are layers after layers, and by the time you collect all the privacy laws, maybe it will be 10,000 page document which you will not understand. So in other words, you are entering into a field where actually it is very difficult to do the audit. There are no professionals who can do the audit of what kind of privacy algorithm has to be there. The algorithm itself has to be audited, because it is extracting data from mobile devices, right? So point is, all you lawyers who are actually, are supposed to be protecting the people, okay, from people who will also always look out for extraction, you should know that your profession is going to be very, very complex. In fact, putting things in a very simple manner is going to be complex, because you have complex situations that are supposed to be resolved. In the first place, you need to understand it before you even argue it. So please gear up yourself, understand that a lot of things are going to change too soon. AI is going to change, your privacy itself is a huge In fact, there's nothing private. Everything that is there on the mobile phone is completely hackable. There is nothing private. Everything is watched, everything is extracted from the mobile phone. So in other words, these are all myths. So how do you protect people is the challenge that you have to face. And I wish all the lawyers to basically think about these complexities, read and understand it. And one of the key things that you have to develop as a skill is, as the dean was saying, that research is the best tool, and there is no alternative to your research. So please do that, and best wishes for you as you go along. Thanks for visiting us. Thank you very much.
Thank you, sir, for enlightening us on the recent developments of AI and research which is to be done by all the students, including the research scholars also. So it gives me immense pleasure to propose the vote of thanks. First and foremost, I would like to extend my heartfelt gratitude to Honorable Justice N. Mala, Judge, High Court of Madras, for accepting our invitation. Thank you, ma'am. And blessing our participants and students of School of Law. Your participation in judging the finals have been very much enriching, ma'am. I would like to extend my gratitude to Dr. Anand, Dr. Asha, Advocate Raja, and Advocate John for accepting our invitation and being a part of the bench of the finals of the 10th annual Moot Court competition. Your dedication has been very much instrumental in making this event a memorable one. Thank you so much, sir. I want to thank Honorable Pro Vice Chancellor Professor Vinay for your unwavering support and commitment, and being with us through the entire event and helped us in all manners in organizing this very successful 10th annual Moot Court competition. I want to thank Dean Professor P. Sri Sudha for being such a wonderful support for the Moot Court Society and Moot Court Committee members. Thank you would definitely be a very small word for you, ma'am. I mean to express my gratitude from the core of my heart and also on behalf of my students. Thank you so much, ma'am. I would like to thank my faculty team members, namely Liji Madam, Lakshmi Madam, Shaktivel Sir, Azhar Sir, Priyanka Madam, Pushpam Madam, the list is huge, Mangal Charan Sir, Shahzad Sir, Jaideep Sir, and finally Deepika Ma'am. Thank you so much for rendering your support for this entire event of 3 days, as well as from framing of the problem to the conclusion of the event. Thank you to all my students. It would definitely you need a huge applause. I would request all the people a huge applause for all my student team members. Specifically, I would to mention Surya, Bhagwati, Prasanna, Sharon, Shubhanita, Asma, Nikita, Yashwant, Sanjay, Delicia, Abhanaya, Abdul, and Prabhakaran. Thank you so much. You people have made such a wonderful contribution, bringing 50 participating teams in one platform. Making this event a seamless one is a wonderful job that is being done by you. Thank you, the supporting staff, the office staff of School of Law, SRM IST. Thank you, everyone. Thank you, the participants from coming all the way from your place to School of Law, SRM IST. We would like to see you once again in our next annual Moot Court competition. All the best. Thank you very much. Have a wonderful evening.
As we draw curtain, let us stand together for National Anthem.
जनगणमनाधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जाहे तव शुभ आशीष मांगे जाहे तव जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे